morning. This hearing is called to order now. This is the public hearing of the City Council Committee on Housing, Neighborhood Development, and the Homeless. The purpose of this public hearing is to hear testimony on Bill number 170827 and to take testimony regarding the impact of squatting in the city as authorized by Resolution number 170841. I recognize the presence of a quorum of committee members. Members of the committee in attendance are, to my immediate left, Vice Chairwoman Blackwell, Councilwoman Blackwell. To her immediate left is Councilman Oh, and to my immediate right is Councilman Taubenberger. If any of my council member colleagues have any opening remarks, I'd like to recognize them at this time.
Mr. Chairman, I do.
I'd like to recognize Councilman Taubenberger.
Good morning to my council colleagues, to today's witnesses, and all those who are here for this very important dialogue. But may I please ask everyone for just one moment of silence for the victims of yesterday's tragic shooting in the Sutherland Springs Church. It's, I think as Americans, we're facing this way too many times, and it is an awful situation. But in their memory and for humanity, I'd like a moment of silence. Today marks the first City Council Committee hearing on Philadelphia's growing squatter problem. For those unfamiliar with that term, squatting is really an act of criminal trespass or unlawful occupancy. For most people, owning their home, it's a definition of the American dream and the most critical financial investment a family will ever make. But for those homeowners dealing with illegal squatters, home ownership has become a complete nightmare. Most often, unscrupulous people find a home in which the lawful homeowners are away for a period of time. They are then illegally break into the empty house and set up residency. There seems to be an underground network of squatters who either scan the neighborhood for vacancies, find through the real estate listings and target empty homes in the city. Northeast Philadelphia has seen its fair share of squatters, but I truly believe that is through all the city of Philadelphia. Our police officers are usually the ones first called by lawful homeowners, but the police are at a complete disadvantage. Often the unlawful inhabitants of the house produce a phony rental lease, claiming to be a tenant of the house. Our police officers have neither the time nor the ability to track down the authenticity of this lease. Unfortunately, the state laws that govern so-called squatters' rights are archaic and afford the illegal inhabitants an equal or sometimes more rights than the actual lawful homeowners. To be clear, there are certain unscrupulous landlords in the city who take advantage of renters that cannot be permitted either. But the focus of this hearing and our resulting legislative remedies are focused on illegal trespassers and unlawful occupants. This hearing pertains to actions that can be construed as criminal acts and does not pertain to example of a landlord and tenant relationship or anyone who had at one time the legal right to occupy the said residence. Examples of these cases would include foreclosure or homeowners or an oral rental lease gone awry. My office has been in close communication with my friend and colleague, State Representative John Taylor, who actually brought this to my attention earlier this summer. John Taylor is here with us today on updating the existing state legislation to close loopholes and afford lawful homeowners more safeguards against illegal squatters. Both of our offices have been in contact with Mr. Greg Rowe, Chief of Legislative Unit of the District Attorney's Office, and also with families who have lived or are currently living through the nightmare of squatters in their homes. Given that, we believe crime is being committed in these cases, and there is no landlord-tenant relationship whatsoever. We'll also be interviewing legal experts from the District Attorney's Office and the Police Commissioner's Office, real estate professionals and government agency specialists in these disputes, and hear directly from those who have been victimized by the squatters. It is up to us in the state and local government to resolve this problem, and Monday marks a significant first step to this remedy. I'd also like to say there are probably folks that have not even come forward yet or that are being victimized by the very same thing. And I would make my office available for anyone that is going through this difficulty, and we are here to serve. So, Mr. Chairman, thank you for these few moments.
Thank you, Councilman. And Councilman Oh, I'd like to recognize Councilman Oh.
Thank you very much, Mr. Chairman. I appreciate very much Councilman Taubenberger's resolution to have hearings and all the work that's being done. However, concerning my bill, I present a bill that I would like to have passed out of this committee with a favorable recommendation. The reason I say that is because we already have a criminal statute, and it's very clear. There couldn't be anything more simple or easy to understand or more relevant to the average citizen than someone violating their home, breaking into their home, entering illegally and unlawfully. We have different types of situations. Some are clearly landlord-tenant issues. Those are resolved in a civil court. Some are clearly criminal, kicking in a door, breaking into a house, smashing windows. Those are clearly criminal, and the only entity that is designed to deal with public offenses like that are the police and the district attorney's office, our law enforcement entities. There's no other way to deal with that. Our civil system is not designed to provide appropriate justice in a private civil court hearing. For example, homeowners do not have a business license. They don't have a renter's license. They don't have a certificate of compliance. They don't have any of these things because they're not renting. They don't have a certificate of vacancy because their home is not vacant. And therefore, they go into a court system and clog it up with a matter that will take up to 16 months, if they're lucky, to remove a criminal. Before citizens take matters into their own hands, it's important that we clarify for our city, for our police, exactly what their responsibilities are. Taxpayers expect the police to do their duty. They are trained, they go through training, and they are supervised. Police do not simply arrest someone and conclude that they are guilty. The process is one in which they need probable cause, and it's a thing that they do every day. Let me start with my statement. Bill number 170827. A person who breaks into your home and refuses to leave is not a tenant just because they say so. That person is a criminal and should not be treated like a tenant without credible evidence. In obvious cases of burglary or criminal trespass, squatters should be arrested and prosecuted. In less obvious cases, there should be an expedited civil process. It should not take 9 to 16 months to remove a criminal from your home because you're forced to hire a lawyer and use a civil proceeding that is not designed to deal with criminal violations. In the meantime, you must continue to pay utilities and all costs. Even after these criminals finally leave your home, they are not punished with jail or fines. They do not pay rent or reimburse you for the damage to your home. It's not surprising that they often do it again. Opponents of my bill object because they say the police are not able to distinguish obvious cases of criminal trespass and fraud. Yet the police investigate murders and complex economic crimes, computer crimes every day. The district attorney's office can determine whether there's enough evidence to file criminal charges, and the courts can decide whether the evidence against the defendant is beyond a reasonable doubt. Today, there's a serious problem of criminals breaking into homes, falsely claiming to be tenants, and a failure in many cases by police to act because of arguments such as those that are being made by the opponents of this bill. Criminal laws are enforced by the police, prosecutors, and criminal court. Civil court is not designed to appropriately address criminal violations. Clogging up civil courts with criminal matters that do not fit in the system takes even longer than the regular civil cases and is burdensome to all. The argument that no one should be arrested because landlord-tenant relationships are legally complicated is completely wrong. Arrests where probable cause exists, as determined by a trained and sworn police officer, is the law and the standard. The arrest merely initiates a criminal process against the alleged offenders. Charges have to be brought by the police, approved by the district attorney's office, and found sufficient by the court. Only then can a trial begin. If at any point the police, DA, or judge determine there is not enough evidence that a crime has been committed, the criminal process stops. My bill does not, because it cannot, make the police arrest criminals. They should, and I urge the mayor to ensure that they do. What my bill does is help the homeowner who must deal with a criminal that is not arrested and remains in their home. It lays out a process that will expedite a civil hearing. While my bill lays out the foundation for that, I cannot make the court have an expedited process. The court is a separate branch of government, and they're not subject to my bill. They must decide to create an expedited process on their own. I've already met with the judiciary to discuss this. However, even if it happens, that process will not resolve this problem within 24 hours. Hopefully, it could take place within 30 days. But that will take more tax dollars for both the city and the courts in order to establish this system. But for criminal offenders who break into homes, the only process we as a government endorse is the police enforcing the law. Otherwise, you'll have citizens enforcing it by themselves, and that's not what we want. In these three separate instances, clearly a landlord-tenant issue, clearly a criminal issue, this bill provides some guidance to the police as to what is and what isn't acceptable in terms of the argument that I am a tenant. It does not apply to gardens. It does not apply to abandoned buildings. Abandoned buildings are already a defense in the state criminal code. This applies when there is evidence that a crime is being committed, but the police do not feel, or the district attorneys, that there's sufficient probable cause. In that instance, we create a expedited hearing, we have the identification, and we institute a fine. And what we have found in this process is that there are professional squatters who have money, who have homes, who have the ability to pay these fines, and what we're seeking is voluntary compliance. This problem has existed apparently at least for a decade, if not longer. And so the argument that we have just learned about this, I think, is problematic. In fact, I feel that we should take care of this today because it is long overdue. Thank you very much.
Thank you, Councilman. And I'd like to recognize to my immediate right, Councilwoman Gim. You have a few opening remarks?
Just very brief. Thank you so much, Chairman Dom, and appreciate the importance of this hearing. You know, I don't disagree at all with my council colleagues' concerns about the urgent issue that is going to be laid out before us. But I do think that some of the testimony that's being presented raises some of the legal questions. And while I don't think that holding a bill to work out some of the legalities of a question means anything about the seriousness to which we pay attention to these issues. I do think it's important that we listen to the fullest amount of the hearing, including some of the concerns that are being raised by some of our strongest advocates who've been very present, who certainly don't want to see outrageous situations, which I think the councilman is trying to address, but would like to see us do it in ways that meet the requirements of the law and help us put out policy that is responsive to, and recognize that policy that we put out there impacts people beyond specific circumstances, beyond circumstances that we may not even understand or recognize. And that's why when we take these approaches and we look at policy like this, we want to make sure, and I certainly would like to hear a legal opinion on the bill from our law department before moving forward as well. So thank you very much, and I look forward to the testimony.
Thank you, Councilwoman. Okay, we have a lot of people testifying today, over 25, I think, so far. So I want to set a few ground rules if we can. I'd like to keep the testimony to within 2 minutes of each person. I have a timer, by the way, here. And I'd like you to either summarize or keep the 2 minutes, but keep everything to 2 minutes if you can. Also would like you to possibly, of course, state your name, but also indicate whether your testimony applies to the bill or to the resolution or to both. And I'd like to ask the clerk now to read the title of the bill and the resolution being considered by this committee today.
Bill number 170827, an ordinance amending Title 10 of the Philadelphia Code entitled Regulation of Individual Conduct and Activity, Chapter 10-800, Safety, by adding a new section 10-840, Squatters, establishing and clarifying procedures to remove squatters from real property, all under certain terms and conditions. And resolution number 170841, resolution authorizing the Committee on Housing, Neighborhood Development, and the Homeless to hold hearings to discuss the impact of squatting in Philadelphia, the victims of squatting, and additional measures and best practices to prevent squatting.
Okay, I'd like to call up the panel number one, and we have our tremendous representative from Philadelphia and State Representative John Taylor, who has clearly represented all Philadelphians, Andrew Gentleman, Michael Barry, Captain Francis Healy, and Rebecca Swanson. Please state your name for the record, and I guess each department you're with. I want to make a correction. Matthew White is representing Captain Francis Healy.
Morning, Councilman Dom and members of the committee. Thank you for giving me and the rest of the panel, all these testifiers, an opportunity to talk about illegal trespassing for the purposes of occupying a residence. And I think that's what we're talking about. As Councilman Oh just mentioned, this is not a new process. He mentioned it going on for a decade or so. I think it's been going on for a long time in Philadelphia, depending on different periods. It comes and it goes. But it's become more sophisticated and more problematic for individual residents. Our office got involved in this particular problem through the neighborhoods of Wissanoming and Frankfurt and Tacony, where individuals were recognizing properties that were being foreclosed upon. And in that case, they would enter the property, neighbors would call, but in those situations, the owner was not there because in many cases it would be a bank from Arizona or from Florida or somewhere else. So there would be little in the way of standing for anyone to step forward, and I think that put the police in a bad situation. But more recently, the perpetrators of this crime have become more bold. They've broken into houses immediately. We've had situations that you're going to hear direct testimony from on Wakeling Street and Akron Street, both from the Wachoff family and from the McGee family, where they occupied the premises, were able to thwart police activity by way of fraudulent documents. Worse, they prey on unsuspecting citizens by renting them the very property they had no right to be in the first place. So what do we do? I think we need action both at the city level, at the state level, and in the court system. And I think we need to work collectively to solve this problem. The bill I've introduced is House Bill 1874. It was not complete. There's been a new bill that has been worked out with our staff and the district attorney's office, and I'm going to let Andrew and Mike talk about that. But basically is, what can the police do and when can they do it? And we need to have that clarified. I think this bill will go a long way to do it. But I think we also need city legislation and cooperation from the courts. And with that, I'll turn it over to Mike Barry and to Andrew Gentleman.
Thank you, Senator. Good morning. On behalf of District Attorney Kelly Hodge, thank you for inviting us here to this important hearing. My name is Mike Barry. I'm the deputy of the pretrial division in the Philadelphia District Attorney's Office, which means I supervise the DA's role in most arrests. With me is Andrew Gentleman, the chief of the Public Nuisance Task Force in my office. I want you to imagine that you walk into your house one day and find somebody else is living there. Maybe this is your primary residence or a second house, a rental property. Maybe it's a home that belonged to your mom and dad that passed along to you, or a home that belongs to your church or community organization. And imagine that you can't get anyone from the city to remove this person. Maybe you have nowhere to live because someone's moved into your home. Perhaps the locks have been changed. Maybe you can get a hearing in a court hearing in a few months, maybe you can get somebody arrested. But in the meantime, practically speaking, your house is no longer yours. And the government, either through the current law or operational issues or some combination of both, currently can't help you in a timely manner. Your house has been taken, you've done nothing wrong, and you're a victim. We wanted to speak to you today about how to help these victims. Because sadly, what we're describing is happening in Philadelphia and in other parts of the country, and you'll hear from some of these people today. Now, before we explore this troubling problem, I want to make clear, we're only talking about illegal occupants, trespassers. While we recognize the issues can get confusing and sometimes overlap, we do not in any way want to create a solution that would empower unscrupulous property owners to circumvent the legal process, to unlawfully evict or harm their tenants, or to trample on tenants' rights. The people here we're to talk about are not tenants by any legal definition. They are trespassers who have illegally entered a person's home with an intent to stay. Now, why do these victims whose homes were taken from them have so much trouble getting them back? There could be many reasons, but two to consider are that it typically takes a significant period of time to go through the current civil ejectment process. And there are some concerns that the city's self-help eviction ordinance may have unintentionally stymied some efforts by other city agencies. As it stands now, there are only two ways to remove an illegal trespasser: an arrest or the civil ejectment process. Arrests are what I know about, and a quick arrest of an unlawful occupant is not necessarily a good solution in many cases. While an arrest would result in the removal of an illegal occupant, an individual who no longer has access to his home shouldn't have to wait until a criminal investigation is completed before having the opportunity to repossess their home. It's always a bad idea to rush to judgment on criminal arrests. And there are many situations we have found where a person may be an unlawful occupant but not warrant arrest, such as when they themselves have been fraudulently offered a home by someone who doesn't own it. Arrest should be about starting a criminal proceeding, not a means to an ejectment. There are solutions. We've been working with the Representative Taylor, Senator Taylor, I'm sorry.
You'll get me in trouble.
Okay, I apologize. On state legislation that would address some of the problems. His legislation is modeled after recent legislation that was passed in the state of Washington. It permits a law enforcement officer with probable cause to believe a person is committing a criminal trespass on residential property to either arrest and remove the person from a premises if arrest is needed, or to simply remove the person without making arrest pending an investigation. Additionally, the owner or authorized agent of the residential property may initiate an investigation by providing a sworn statement signed under penalty of perjury. This statement would include that, among other things, he or she is the owner or authorized agent of the property, the trespasser is not a tenant or an invitee or permitted to be on the property and has instead remained on the premises, that the owner has demanded the person vacate the premises and the person has not done so. The person who's entered the property would also be provided an opportunity to present to the investigator any credible evidence showing that he or she is an owner, tenant, legal occupant of the premises, or a guest or invitee thereof. This narrowly crafted legislation would go a long way towards providing proper owners a legal and safe method of reclaiming their property from trespassers. We also believe that collectively we should look at Section 9/1600 of the Philadelphia Code, which addresses the issues of self-help eviction practices, to see what changes, if any, are needed to ensure that city officials are appropriately empowered to remove illegal trespassers. As part of this analysis, consideration of Councilman Oh's proposed resolution is important. Councilman Oh is the man who brought this issue to my attention. This legislation correctly assumes that the process for an owner to reclaim his or her property needs to be changed, and that there needs to be a quick way to provide a quick and substantive adjudication of the claim. The resolution currently acknowledges that owners of records of real property should be the beneficiary of a legal presumption when no proof can be provided that a landlord-tenant relationship ever existed. Councilman Oh's proposal widely focuses on the people whose homes have been stolen and that the law needs to protect them because they're the victims. By adopting a formal written process, we'd be ensuring that the law does not unintentionally benefit unscrupulous owners or landlords, which again is no one's purpose here today, while still acknowledging that as victims of these crimes, property owners should be protected by the law, not thwarted by it. I thank you for your time and your consideration as we try to help victims of crime in Philadelphia get their homes back.
Thank you.
Mr. White? Mr. White.
At the end, yeah. We're going to hold all questions until all 5 of you have testified. Please proceed.
Good morning, Chairman Dom, members of council. My name is Matthew White, and I'm an advisor to Police Commissioner Ross. I would like to thank you for the... Oh, thank you. I apologize. Thank you for allowing the police department to comment on both the bill and the resolution. As you well know, the officers of the Philadelphia Police Department are called not just when outright crimes occur, but are also called to resolve a wide range of disputes, ranging from child custody matters to property line squabbles between neighbors, and inevitably to resolve landlord-tenant and other property ownership issues. Regrettably, these matters are complicated with dueling documentation records and the implications of City Code 9-1600, which prohibits self-help evictions. The officers are often left with the untenable task of trying to resolve these matters on the street with no access to official records. I think it is important at this point to clarify the difference between the common perception of a traditional squatter from the intentional criminal acts that we have seen over the past several years. Traditional squatters are individuals who enter an abandoned facility to use as an impromptu residence or shelter. There are no indicia of any ownership or leasehold interests. This is the classic version of a squatter. However, increasingly, we are finding individuals who intentionally enter an unoccupied or even occupied structure to deprive the true owner or leasee of the right to the property or to extort the owner into paying them to leave the property. This is not a squatter seeking shelter or a landlord-tenant dispute, but rather a crime. Regrettably, this crime is not easily identifiable. It takes investigative work that is simply beyond the scope of the responding patrol officer. These criminals are aware of the current city code and are savvy enough to produce fraudulent records and leases and even legitimate utility bills. To deprive an owner of their home or to extort them for its return is offensive at every level, and the Philadelphia Police Department will do whatever it can within its power to bring these criminals to justice. Unfortunately, justice in these matters is far from swift, which leaves owners doubting the integrity of not only the police department, but our government as a whole. Clearly, law enforcement and legislators need to come together to address this threat, so the Philadelphia Police Department applauds the efforts of both Councilman Taubenberger and Councilman Oh for bringing these issues to the forefront for discussion and debate. While this matter is debated, I think it is important to remember that the intentional act to deprive a person of property or to extort an individual is a crime and must be treated as a crime, where swift and definitive action can be taken by law enforcement to abate the harm. While City Council has the authority to address this matter through the City Code, the police are limited in what we can do with enforcement. The ability to issue a code violation notice may be helpful to establish notice in a criminal case, but the code will not authorize police to forcibly remove individuals for code violations. Thus, the harm continues for the owner. For this reason, the police department would strongly recommend that our state legislators be included in developing a comprehensive solution to this somewhat new and complicated crime. To that end, I commend the efforts of the District Attorney's Office and Senator Taylor, as previously mentioned by Mr. Barry. With both city ordinances and state laws attacking the issue, we believe a synergy can be created that will allow a swift and fair justice when required, but without intentionally criminalizing traditional squatting activities. Thank you.
Thank you for your testimony. I think we have 2 more.
Good morning, Chairman Dom and members of the Committee on Housing, Neighborhood Development, and the Homeless. I am Rebecca Swanson, Director of Planning for the Department of Licenses and Inspections. I am here to provide testimony on Resolution Number 170841 and Bill Number 170827, which address the citywide impact of incidents of unlawful trespass into residential properties. I'd like to thank the committee for inviting Elle and I to be part of this important discussion. As the resolution states, there's a difference between what is commonly thought of as squatting, which can encompass a number of complicated situations in which an individual is legitimately living in a home without clear documentation, or in which an individual seeks shelter in what is clearly a vacant and abandoned property, and the criminal trespassing we are here to discuss today. A situation of an individual breaking into a residential property, changing the locks, creating a fraudulent deed or lease, taking over the utility bills, and refusing to leave at the request of the rightful owner is clearly a criminal act that can have a significant impact on both the owner of the home and the neighbors, and should be handled as such. While criminal trespass is not a property maintenance or building code issue that can be addressed through code enforcement, the department can offer suggestions to property owners as to ways they may be able to protect themselves from this crime. We recommend that any property owner who intends to leave their property vacant for a period of time obtain a vacant property license from the department. Section 93905 of the Philadelphia Code requires that the owner of any structure that, quote, lacks the habitual presence of human beings who have a legal right to be at the premises, or at which substantially all lawful business or construction operations or residential occupancy has ceased within the past 3 months, to obtain a license. Because possession of a vacant property license shows a clear intent on the part of the owner to keep the property vacant, the existence of such a license could be used as evidence that any occupants of the property are there without the owner's consent. Similarly, owners who choose to rent their property should always have an active rental license. The department agrees that unlawful trespass is a public safety threat and that homeowners deserve protection from this criminal act. As such, the issue deserves serious consideration. However, it is important to continue to note the difference between criminal trespassers and individuals who may legally occupy a building without clear documentation, people who we see every day as code enforcement officials. There are approximately 273,000 tenant-occupied residential units in Philadelphia. Not all of these residents have a written lease or utility bill in their names, nor are they legally required to. There are also thousands of other units in the city occupied by those who consider themselves the rightful owner, but because of a tangled title, deed fraud committed by another person, or a rent-to-own agreement, may not have the paperwork proving themselves to be the owner. We do not support a solution that could lead to these individuals being removed from the homes they legally occupy because they would be unable to provide certain documentation, leaving them homeless and leaving the community with a vacant building. Whatever solutions there are to prevent trespassers from illegally seizing control of a property must take into consideration the large number of citizens who could be adversely impacted. As the code enforcement and building safety agency for the city, the department is committed to working with our fellow city agencies, city council, and stakeholders on these potential solutions. Thank you for the opportunity to testify.
Thank you. Thank you for your testimony. Thank all of you for your testimony. I think my colleagues may have some questions. So I'll start with Councilman Taubenberger.
Thank you, Mr. Chairman. Just to clarify, and this is a question both for State Representative Taylor and Mr. Berry, and that is, do you find it essential that state legislation be enacted before we can introduce, well, not necessarily introduce, or pass any other bill at this moment? I mean, does that give it strength? Does that make it happen? Because most people don't realize it. The state is the sovereign. Cities exist because states allow them to. And I'd like to have your comment.
Councilman, as problematic as this situation is in Philly, it's also statewide. Okay. And I think for the purpose of the bill, and I'll let Mike speak to it as well, but the purpose of it is to really clarify when police can get involved in a civil situation and/or when a civil situation warrants police activity. And it's really very clear to the victim,
right,
what situation it is, but to the police officer showing up at the scene, he has to make a decision, and I want to thank you for your involvement in both the Wakekoff and the McGee families, and
thank you.
And you're talking to the police, and I think even in that situation, the police saw it differently in two different situations a quarter mile apart.
Right.
So this legislation, I think, clarifies that. Would give council an opportunity to narrow it or expand it. And as was mentioned, this is not about landlord-tenant rights. It's not
right.
about unscrupulous landlords. It's about trespassers. Mike?
And if I could add first regarding the need for action at the state level, I can tell you on behalf of the district attorney's office, and I feel fairly comfortable with the police department too, the state crimes code tends to be the first resource the police go to when they're trying to see if there's a crime and try to get clarification on what to do. Absolutely, that is the same with us at the DA's office. So having clarity at the state level would be very helpful on that level, to that extent too. The legislation as proposed, I think, clarifies the simpler situations, which unfortunately, they can be more complex than we'd hope, but the situations where there's, a broken window or a kicked-in door and a person staying somewhere, the police have a pretty good understanding of what's happening there, and they feel comfortable it's a felony, they can make an arrest on the street. As we've seen, if somebody provides a fraudulent document, in the matter I handled with Councilman Oh, where a woman claimed to have rented the house on Craigslist, it takes some investigation by the police. And a full criminal investigation probably takes longer than what is fair to the homeowner as far as seeking someone out of their house. The legislation hopes that by having people come to a police station and give a sworn statement, that it will provide a certain level of assurance that this isn't going to be an unscrupulous homeowner or renter making something up if they're going to have to go to a police station and essentially commit a felony and lie in a sworn statement. Same thing with the occupants. It's one thing for an occupant on the street to make a quick claim to say, oh, I rented this on Craigslist. If you require them to come to the police station and give a sworn statement saying they rented this on Craigslist, and they're willing to do that, all right, well, now an investigation has to be done. Right. But we suspect they won't. We suspect that'll be a good tool to weed out the fraudulent claim versus the actual dispute, which is what I believe we're all trying to do here. So I think that's the strength of Representative Taylor's statute. Although I reiterate what I said in my testimony regarding Councilman Oh's, the presumption. A homeowner with legal documentation, I understand there can be unscrupulous homeowners, but in particular, we have cases where these are people's primary residences, not a rental property. There's got to be, we feel, some sort of presumption that if they can provide legal documentation or are willing to go to a police station and take an oath or sign a sworn statement that they did not rent this to somebody, that could be the basis for quicker action than civil ejectment.
So the state legislation would remove the fog over this and would make any legislation that we come up with much more clear.
I think so. I think it gives a quicker process for dealing with the immediate issue, which is the person in the house, while letting both the criminal investigation and any other issues that may exist play out.
And we do have some victims that will speak a little later, but I think they, in the end, want clarity so this could move quickly.
Yeah.
And I think that's where the frustration. Thank you very much, Mr. Chairman. Thank you.
Thank you. Councilwoman McGinn?
Yes, thank you very much. First of all, Representative Taylor, thank you so much for everything you've done for Philadelphia. It's been a real honor to be able to work with you on many different things, including all your work that you've done on education, schools in particular. Very grateful to you for that. One of my questions is your bill. Do you feel like the clarity that is needed at the state level around this should precede any municipal bill that moves forward? Does it make sense for us to move municipally ahead of the state clarifying and having potential confusion around the two until there's clarification at the state level?
Yes, before it's implemented. As both bodies deliberate, it probably can happen simultaneously, but starting with the fact that this legislation allows the police to remove someone without a necessity of an arrest. So I think that really will be important before any city legislation is actually implemented. But I think we can both work hard on it simultaneously. We'd like to get this bill out before the end of the calendar year, with the support of
The state bill, sir? I'm sorry, Representative, did you mean we as in the
No,
state plans to?
in my end.
Okay.
With the support of the Pennsylvania District Attorneys Association, I think that that can happen. And I think that, again, we in Philadelphia are not the only ones going through this. So there's members throughout the Commonwealth that have a similar situation. I mean, I think they may choose to handle it differently, but I think they all need that clarity.
Thank you very much. And then for Mr. Gentleman, my question is, there are, I don't know, maybe 14,000 tangled titles that we've got going on in the city of Philadelphia. I think Commissioner Swanson talked about 273,000 tenant-occupied properties. We've got forged deeds, and we also have oral leases, which are recognized at the state level. They do not require something in writing. Given that, the bill specifically asks that police be the determiners within a specific time period to determine whether someone has a right to be in the property. Do you think that, given the circumstances around that, do you, on behalf of the district attorney's office, believe that the police should determine that? And I'd like to ask the district attorney's office to answer, and also for the police department to answer as well.
Thank you, Councilperson. My reading of the bill would actually, most of the situations you named, would probably not result in a quick ejectment. Under the hope and the understanding that if there was either unscrupulous action on a homeowner, and that homeowner was, or a landlord, and that person was, we would hope that if they're lying, that it would be deterred from going to the police department and lying under oath about the particular home situation, and therefore that procedure wouldn't take place. Or that if they came in and there was a legitimate dispute and they gave their side, and a tenant had a claim of an oral lease or had a claim of a non-registered lease, or they have it as part of an estate but never had it officially in their name, that they too would go to the police department and be willing to give a signed statement to that effect, which would then probably, hopefully, lead to moving to the civil ejectment process like we have now. Those tough cases where there's a dispute are still going to be a dispute. What we're hoping this legislation will do is those cases that aren't a legitimate dispute, they're a person on the street making a claim that they can't back up in any way and that they know scrutiny will show that they're not telling the truth, they either wouldn't go to the police station and the homeowner would, or police investigation on the street would allow them to do that. Obviously, we all know the police can now arrest somebody for trespassing on the street. The question is, I think that they need some guidance on the tougher situations. And the hope of this legislation is that while still giving the police the power to arrest on the street when they need to, having them go down to the police station and have some sort of process where people have to sort of speak on the record, give their position on the record, would deter obvious frauds from making these claims and would then funnel the real conflicts through the system that they're supposed to go to.
But they would have to do that forcibly.
Excuse me,
They would have to bring somebody down to the police station forcibly to make a statement.
No, they wouldn't have to bring them forward. They would be afforded the opportunity to do that. The person who's on the premises who is making a claim to have a lawful right to the premises will be given the opportunity to go to the police station, not forcibly, to state their claim under oath. And if they do that, my expectation is that the police department then will either, depending on the specifics of the situation, refer it to the civil courts or start a criminal investigation. But I don't know that necessarily in that situation ejectment would happen. My understanding of this bill, it presumes cases when the purpose of this is to keep fraudulent actors from going down to a police station to make that fraudulent claim. They would probably, in my experience, disappear upon being told they had to go to the police station.
I guess the question that I have, sir, is that the bill says that once a current owner complains to the police that a squatter is occupying the property, the police shall immediately notify the squatter that he or she must leave the property within 48 hours of such notice. If the alleged squatter can show credible evidence why they should be rejected from the real property, then the matter shall be resolved. But the question is whether police should be able to do that within a 48-hour period, whether a tenant or whomever can be able to do that within a 48-hour period. Are they the best determiners for that kind of question, given the amount of complications that are going on?
Well, my hope is that since there are cases that we think are complicated, but there are also a great number of cases that really aren't, that what we're doing is empowering the police to do what they already have the power to do, which is arrest people for committing felonies, and creating a quicker step, allowing people to state on the record their positions on a case and sort of ask of both sides, both the owner of the property and the person residing in the property, to officially state that they are in fact claiming a right to this property. By way of, again, the one I'm most familiar with, the incident that happened with a woman named Miss Bynes with the Lees, she said the day of that I rented this on Craigslist. But day after day after day, the police would go back seeking proof of this Craigslist rental, and she would never do it. The problem with that particular case is because she made even a very offhanded claim to be a lessor, the police didn't feel like they could get involved, and it spread into months. And then eventually it got so long that somebody said, all right, this has been too long. We can't believe you if you've spent months. I don't really think it should have taken months.
And I would agree with you on that. I think the issue is not to look at the cases, but rather than talk about what we hope the law might be able to do, what we know based on past practice, whether this is really the best use of police procedures discretion and within the bounds of the law, given the context that we currently have with tangled titles, forged deeds, oral leases, and a very complicated system. It's not to in any way say that we should not be paying attention to it, but what is being proposed on the table is a pretty serious and aggressive move towards quick decision-making that has enormous consequences, and any deprivation, of course, on the owner or a tenant of property should require us to ensure that we are making sure that we are meeting the mandates of the law, not what we hope the law will do, but what we know the law's limited capacity to be able to do will be in the best interests of everybody.
Well, I mean, I can let Mr. White speak about what's the best use of the police resources. I can tell you that the police are stuck with this regardless of this law. I mean, they're the ones everybody calls when somebody's there. When somebody's asked to go to a civil ejectment procedure that's going to take months, the police repeatedly get the call saying, why is this taking so long? And we do empower, and just so you know, when I'm talking about empowering the police, I'm not talking about letting the cop on the street who took the 911 call necessarily make the call, but I'm talking police along with the leadership of the detective division and consulting with my office, the ability to make some decisions regarding this. What I'm really, I hope it can be seen in this light, is that right now the only thing they can ask us to do is arrest someone, right? And that's fine. I mean, we arrest people a lot. You know, that's fine. But we've recognized that there's a middle ground here that may require action that may not require immediate arrest. And I know on our office's end, and I believe on Representative Taylor's end, I don't want to speak for him, but we're just trying to come up with a solution for that middle ground. I agree, and I'm less of an expert than other people here on the complexities of tangled leases, oral leases, estates. So I'm not denying that all of that exists. I'm just saying that our hope is that the statute will keep people who are simply fraudulently claiming a claim to a property would have to do something but besides just say that on the steps of the House before we start this whole process. And that, I think we'd be open to other solutions, and I think everybody here, if it were possible, would be open to a quicker civil ejectment process than currently exists in the city. I think that would give peace of mind to both sides if it weren't up in the air for so long. But I don't have the power to do that, and I would just think that this legislation allows for information to come on the record and to people that have to state under penalty of law their position before all those rights kick in.
And Mr. White, just for clarity, I did not in any way ask questions about the use of police resources. I was more asking a question about discretion within a relatively short time period, so I'm curious about your response to that as well. Thank you very much.
And really, just speaking from firsthand experience, I think there's often a great range in the difference between what people will say in the confines of a private residence or on the street versus what they will say seated at a detective's desk in a detective division and being asked to put pen to paper and sign a statement. And so I think having a mechanism to compel them to that venue to sign an official statement with a detective would be to the benefit of resolving these issues.
Did you speak a little bit to the question about whether the 48 hours and the discretion for police to make the determinations in that time period make the most sense to you?
I can't speak about 48 hours specifically. I don't know what the answer is, but I think if you're compelling people to a detective division, then you're talking about something that's taking place in a matter of hours, single-digit hours, not 48 hours. So I think it's quicker to have both parties come down and essentially swear to their position.
And you think that that can happen efficiently even when people have oral leases or don't necessarily have a utility bill in their name?
I'm certainly not an expert on the range of leases or oral agreements, but I can say that having people compelled to speak, say, on the record in the detective division versus on the street is a better situation.
And Councilman, if I may, I think the legislation seeks to rectify the most clear situations. So a tenant usually does not start his residential occupying of that house by breaking into the property. So that usually doesn't happen. And when there's clear evidence, as we have had in cases where the window is kicked in, the lock is broken, and then the secondary situation of multiple occupants in the house who may or may not have trespassed. I mean, they might not have broken in. So this gives the police an opportunity to not arrest but remove pending an investigation. When the neighbor says, I saw that guy kick that window in, I saw them break the lock and walk into the property, and immediately the police come. Boy, if we don't arrest or remove on that situation and take that example to its extreme, anybody who leaves their house at any time for anything can be subject to this problem. So I think and I understand the complications with the oral leases and the tangled titles, and I don't know if this legislation is going to resolve those. But the most clear situation where I think we can stem the tide of the most outrageous behavior, I think that's what this legislation tries to do.
Yes. And it's your opinion that our current laws around breaking and entering or abuse of property or anything like that do not currently afford the homeowner the appropriate protection?
Under these situations, yes.
Okay, thank you.
Thank you, Councilman Oh.
Thank you very much. Not only are the police the best agency to enforce the criminal laws, they're actually the only agency. L&I does not do it. No other entity can do it. We don't want citizens doing it. And most citizens, by the way, seniors and persons with disabilities, they are not able to do it. So the only entity that can enforce criminal laws are the police. If they do not do that, then I think there's a dereliction of duty. I think that's a huge problem for this city. The police are sworn to uphold the law. They're the only entity that is equipped and trained to do this, and they should do it. We're talking about presumptions, and this is not a new kind of criminal code that was created yesterday. Burglary, criminal trespass, violation of property, breaking into it, that is nothing new, and the police have enforced it time and time again. If we applied this standard as you're talking about it today, any situation, someone could be in my car. I could tell a police officer someone's stealing my car, and a person would say, Councilman Oh lent it to me. Oh, I can't resolve it. I need some paperwork. We need to go through. Maybe Councilman Oh's a rotten guy. How about date rape? How about domestic violence? We want the police to go in, take action, and it can be resolved through the courts, through a process. But there needs to be action taken when criminal laws are being broken. But this bill that I present has nothing to do with the criminal side of things. What it provides is a process whereby there is a presumption, rather than confusion, there's a presumption in favor of the legal homeowner, the homeowner of record who shows up and said, that's my house, those are my things in my house, we were away, we're back, so that the police can have a clear understanding under a civil ordinance what their steps are. And the first thing is the confusion when someone says, I have a cable bill, I have a utility bill. That is not a lease, that is not a right, that is not anything. And in the case that we were talking about the pastor and the woman who broke into his home, she didn't produce anything, and it took over 5 months for the detectives to issue an arrest warrant. What she said after she broke into the home and the Lees came, and then she changed the locks after they came, was she found someone on Craigslist, met them, gave them cash, she's got no lease, some paperwork. When are you supposed to pay rent? Oh, I don't know. They don't answer their phone. And what we're being told in the case of the McGee's is because the woman in the home claims to have been scammed, yet the door's kicked in, the doorknob is missing from the front door, the for sale sign is gone, the lockbox is taken down, their items are in the home. What we're being told is because the woman claims she was scammed, the police are not going to remove her. Now, how can that be? If she's legitimately scammed, she has no right to be in the house. But it doesn't look like she was legitimately scammed. It looks like she's a scammer. And that can be processed in criminal court or not. That's up to the police. What this bill requires is that when a lawful homeowner, someone with proof, calls the police and says, someone broke into my home, the police come and they see evidence of a burglary, they should arrest that person. But that's not, this bill just says they go and ask the person for either a lease, not a phony lease, not a ridiculous lease, not I met someone at a gas station, gave them $3,400 in cash, and I don't have their number, they don't answer my phone, I never made a rental payment. They have to show some legitimate documentation, not a cable bill, not a letter written to themselves. And I've heard all kinds of things from police, and it's not their fault. A police officer said to me, if they show a utility bill or a cable bill, that's proof that they're a tenant. It's not proof that they're a tenant. It's not proof that they're a tenant. This is a civil ordinance. It presumes that the homeowner with the proper documentation who comes up to a police officer and says, someone broke into my house, they're in my house, that the police will then investigate, understand what are the legitimate and not legitimate documentation. They can talk to their supervisors, to detectives, to the DA's office, whomever, and it doesn't require arrest. It's a civil ordinance. It requires identification, and if the police officer finds in enforcing this ordinance that the homeowner has documentation and that the person in the home with the kicked-in back door and a broken window and all that does not produce any credible evidence, the police simply tell them they have 48 hours to leave. They're not arrested. If they don't leave, that becomes the issue. And so there's no need to have any further discussions about this, in my opinion, because there has been a woeful failure to serve the public. And we have victims of crime who are homeowners. And it's ridiculous that we have to have a new civil process for victims of a very obvious crime. I hope that if someone steals my car or beats me with a baseball bat, I don't have to fill out a bunch of papers saying I didn't authorize them to beat me with that bat, I didn't authorize them. I don't need a whole nother set of processes for the criminal side. But the failure right now to respond to lawful homeowners on a very fundamental thing called burglary, criminal trespass, and fraud, which is what it is, we now have to create a civil process to provide guidance to our police officers and at least some understanding to our city that you cannot side with all the criminals in this city under the idea that you're somehow helping homeless persons and persons who need a place to stay. We help them. This is a very tenant-friendly city. We pass laws, we spend money on the homeless and all that. But this is for homeowners, and it is simply dealing with the failure to deal with this process, this portion of violators who the police are not arresting, that are not, they're clearly not tenants. but there isn't enough probable cause to arrest. We can expedite this for the sake of the homeowner. Thank you.
Thank you very much. I have actually a question for this panel. It's a simple question. You can answer yes or no. But I think we're faced with today, we have a bill and we have a resolution. And I'm going to cut right to the chase. The bill is asking us to vote today on what Councilman Oh is discussing, which very powerful statements. We have a resolution to explore all the issues. My question to the five of you is, are you recommending to us to hold the bill? Are you recommending us to pass the bill and work with Councilman Tauberger's resolution to improve the bill as the state puts their bill forward?
Mr. Chairman, I'm only familiar with Councilman Oh's bill from what I've heard him say today. I mean,
Okay.
as an advocate for these victims, I would say both.
Pass the bill.
And I think it all can proceed simultaneously. You'll have a debate about it in council, and we
Right.
will move as quickly as possible in Harrisburg.
Okay, great.
I would concur with Representative Taylor. There's a lot of aspects about Councilman Oh's proposal that make a lot of sense, that don't conflict with the one we're working on with Representative Taylor. So I think both.
Thank you.
Yes, I believe that there are, both the bill and the resolution work towards the same goal, and both should be embraced by council.
Okay, thank you. Planning Director.
It's our understanding that the Law Department has issued a memo and proposed amendments to Councilman Oh's bill. That's pretty significant because it's this long. So my recommendation would be that the committee hold the bill to consider the Law Department's amendments and then for further discussion on the resolution.
Okay, thank you.
I'll speak to that, Chairman.
Councilman has a, I want
Okay,
to
I'll
recognize
just
Councilwoman
quickly-
Kim, and then I'll come back to you, Councilman Oh.
So I just had one question for Mr. White and Mr. Gentleman. In a situation of domestic violence, which I know both of you have dealt with through the police and the DA's office, have you seen evidence of doors that have been broken in or windows that have been broken in as well, and a violent situation that is occurring right then and there?
Yes, I have personally seen that, yes.
Okay.
And just the record, I'm Mr. Barry, but yes, I have also seen that.
One of my concerns is to ensure that in any process, that domestic violence victims in particular, who often can be at the mercy of whoever is able to prove leases, can be threatened under an overly broad law. I think it is important to take a look at what the Law Department does recommend. I hope that instead of, there's no question that we're going to deal with this issue. I really appreciate the representative's initiative at the state level that will bring clarity to the issue. But to move concurrently ahead of the state being able to work out its own processes, to me, means that domestic violence victims, tangled title deeds, forged deeds, oral leases, this is not about the homeless, this is not about pity or charity. This is actually about rule of law and making sure that we are applying the situation broadly to a whole group of people, not to the exceptional circumstances, while recognizing those exceptional circumstances will be addressed. We will not tolerate people who are breaking and entering into other people's homes and taking over them. Again, as I said, I'm grateful to the representative for leading on this issue at the state level where I think it needs to be clarified. And the city will follow suit. But I do want to be cautious because domestic violence victims certainly do tend to fall under this type of consideration. And, we want to be thoughtful about any rules or laws that put them at more significant risk, rather than making sure that they are considered equally protected under the law.
Thank you, Councilwoman. Councilman Oh?
Yes, fortunately, I did serve as an assistant district attorney and have done about 25 years as an attorney, also criminal defense. And I could tell you, I cannot imagine any circumstance, really, where domestic violence or other issues would arise. We have a homeowner with documentation that this is their home, who says that person broke in, there is the proof of breaking in, and they produce no evidence that they're a lawful tenant of any sorts. And the presumption then initiates a process. The problem that I have is also this. that if you're in a rich part of town, you don't have this problem. Believe me, you come home, there's someone in your home, you call the police, they're right there removing them, your neighbors or whatever. But you go into a poor section of Philadelphia or a lower middle class neighborhood, and then it's a toss-up. Will you get service or will you not? And it really, in my experience, comes down to who you know. If you don't know someone, you're not likely to get service. And it is not the fault of the police or anyone, it's just this confusion that I have heard so many things, even from assistant DAs and FOP, not FOP Lodge 5, but other FOP presidents that tell me it's a squatter's bill and all kinds of things that are untrue. What I would also say is I have reviewed the law department's amendments, and I have to reject them. First of all, it further delays the process. Instead of going to a court of law, going to the Fair Housing Commission, which you can appeal from, going through that entire process is not expediting this issue. And I think that because we have not, as a city, provided the consistent level of service to the public that we should have, we now have a huge problem on our hands that is growing. And I appreciate State Representative Taylor, not only dealing with this in Philadelphia, but statewide. At the same time, as we have talked about, this problem needs to be addressed. And certainly, the police and the district attorney's office and the public defender's office and all the lawyers that are involved and the courts will be able to distinguish cases that need to be reviewed more carefully from just blatant crimes where we need to protect the homeowners and they expect us to do it. Thank you.
Thank you, Councilman. Councilman Taubenberger?
Thank you, Mr. Chairman. I really just have to say that the experience you get as a councilman and being on site and seeing firsthand the difficulty that homeowners have, seeing that the fact that the locks have been kicked, the door has been kicked in, the lock has been removed. In one case, it was a lockbox, which all realtors use to show properties and so on. To see that that has been removed and been ignored by the, really put aside by the police is really hurtful as a human being. When you can see that the evidence is right there. The McGee's who were in the audience had the sale sign removed. They had a sale sign on there. Lockbox ripped off, sale sign taken away. That is very, very problematic and something that quite bluntly I cannot stand for. Mr. Wakehoff, he is also in the audience and he will testify, I know he will, but in regards to, he called the police and they were there within hours of the people actually breaking in the home. And still to have to wait and wait and wait is really awful, and not having government do the service it is sworn to do and to protect the people that they need to protect. We're not talking about an institution that is miles and miles away and maybe there was a right and the person maybe used to live there. We're talking about someone who forcibly came in, kicked the door down, and now has decided to sublet it or is there themselves. So to have this matter resolved is of most importance to me and all other members of council and all other law-abiding citizens in Philadelphia. We just really cannot have that. And I'm glad that they're here today, and I look forward to their testimony. But I really want to let you know the passion that I have for this, because I stood there for several hours with State Representative Taylor, also with City Councilman Brian O'Neill on the phone when we were up in Central Avenue, right across from Burholm Park, and to be there as a law-abiding citizen and be almost, there literally without any representation, I think is really awful, really awful. Thank you, Mr. Chairman.
Thank you, Councilman. And I want to thank the panel. Is there more? I want to recognize Councilman Oh, you still have more comments? No? Okay. I want to thank the panel for your testimony, and thanks for being here, and thank you very much. I'd like to call up the next panel. On panel number 2, I'm going to ask Jack Malloy, Kenny Barretts, and Roseanne Connor to come forward.
Morning. Chairman Dom and members of the committee. My name is Jack Malloy. I'm the Government Affairs Chair at the Greater Philadelphia Association of Realtors. Thank you for the opportunity to testify regarding Bill number 170827 and Resolution number 170841. GPAR would like to thank Councilman Tolbenberger and Councilman Oh for inviting us here today. Additionally, we'd like to thank Chairman Dom and his staffer, Jeff George, for working with us and the Police Department and the District Attorney's Office for nearly a year. They have listened to our concerns and have worked towards solving measures. We recognize that some folks are victims, as we heard earlier. We also know that some are complicit in their illegal activity. The latter often refuse to vacate a property and know how to plan the system. Meanwhile, the owner is victimized by going through an expensive and tedious process that denies them their fundamental property rights, including accessing or selling the property. I offer this squatting story that was shared by a fellow member who had an empty dwelling that was listed for sale. A buyer was found, an agreement of sale was executed, a final walkthrough was scheduled the morning of the settlement. The agent and the home buyer went to the house and found a family squatting in the house. Unfortunately, the sale could not be saved and it fell through. A 9-month ejectment proceeding was pursued. The house was finally vacated, repairs were made to the damage caused by the squatters, and it was listed again for sale. A new buyer was found for the property, and unfortunately, the same thing occurred. Squatters tied this house up for 2 years. This is just one, but there are many more stories. We understand that sometimes innocent people are deceived into renting properties by people who pose as fake real estate agents or owners. GPAR is committed to creating a safe city for homeowners and renters. Therefore, it's important to reduce the risks posed by squatters. We support the Council's effort in addressing this issue. We welcome the opportunity to form a stakeholder group led by the Council to be tasked with finding viable solutions. We also encourage, as we heard this morning, the Pennsylvania State Assembly to be a stakeholder in this same resolution. On behalf of GPAR, thank you for the time and opportunity to testify this morning. Thank you.
Thank you. Thank you very much. Ms. Connor, would you like to testify?
Yeah, hi, I'm Roseanne Connor from Connor & Connor. I am a real estate broker and appraiser in Philadelphia. I've been selling bank foreclosures specifically for 21 years, and I want to thank all of you for this. I have been dealing with this for the past 2 years. I had gotten some realtors together. I've had 23 incidents reported in the last year and a half. Of the realtors that I spoke to, we had 50 cases of this happening. It is scary for me when I go to the houses they're broken into. There's been a couple situations that I really wanted to bring out. There was one where we know that sometimes they break in and change the locks, so we check the houses constantly because they are bank properties. We went to the property and the locks were changed, we changed them back. The next day they were changed again, we changed them back. The third day they broke in at 1 o'clock in the morning and the neighbor said they were in there again. We went over there, they cut the gas pipe. And when we got there, when we first entered, the person went in first, started throwing up. That's how bad. The gas company was screaming and yelling at us. We had nothing to do because we thwarted their opportunity to get somebody in there. They went and did that, which was a row house with children all over the place, could have blown up at any time. We've had situations because of our properties, because they are vacant, a lot of times no utilities. We had one we went in where people said they rented it, they sublet the basement to a woman with 2 small babies. The baby was 8 weeks old, laying on the floor in a wet basement with no utilities. She had a TV, a portable TV, and a diaper bag, and 2 babies laying on a blanket on the floor. When I went in and put the light on, scared the heck out of us. I almost had a heart attack. But she said they sublet it to her. Some of these properties are dangerous, and I want to say when we call, a lot of these situations are not reported because we wait for the police anywhere from 2 to 4 hours I usually give up between 3 and 4 hours. I understand it is not an urgency for the police, and when the police come, they are very nice to us. But the waiting sometimes is 3, 4 hours, and then I just leave. So they're never even reported. It is so frequent. It happens so often. I have 2 right now, one in Juniata. People have been there for almost 10 months. Water bill, $400 a month. I knocked on the door. I said, "What are you doing with the water? Are you filling a pool? Like, why are we paying this high bill?" She said, "Do I look like I have a pool?" and slammed the door in my face. Now, again, we called the police. The situations are so out of control. I want to say that when we call the police, we always have a tax record showing that we have proof of ownership. Secondly, we have a statement saying that we are the agent for the owner. I have a statement just saying that I am the agent for the owner. And we have a rental license, a vacant property license on every one, except the ones where it happens so soon, we can't get a license until the deed's recorded. So we apply on every one immediately as soon as we can. Having proof of who we are, having sometimes writs. We've already done an eviction. We go there, knock on the door, and still the police said they can't take us out. We also offer these people, to add insult to injury, we offer them an average of $2,500 to leave, the squatters, and they say no because we can be here for so long that we don't have to do that. I mean, it's insult to injury. It's dangerous for us. It's dangerous for the people moving into these houses that are not fit for I had one lady said she rented it, and she said they told me if we get evicted during the time we're here, they'll give us a free property. They'll give us another one, they'll transfer us. No one would question why you would be evicted from a house that you're legally renting. One lease, and final, because I don't want to go on too long. One lease actually said it was between the tenant and the landlord. The landlord's name was Realtor, 2 words, Realtor. And even the policeman said to me, who actually would believe this? So it is scary for us. I go into houses that have been broken into. I don't know if they're in there. We can't call the police because they can't do anything. And I've been living with this for almost 2 years. I've had 23 situations in the last year and a half, and I just want to thank you all for whatever you can do. I really, really appreciate it.
Thank you for your testimony.
Thank you.
Mr. Barretts?
Good morning, Mr. Chairman, members of council. Initially, I would just like to thank Councilman Oh.
You have to identify
Councilman-
yourself. Just identify yourself for the record.
I'm sorry.
That's okay.
Ken Barretts, I'm an attorney here in Philadelphia. I want to thank Councilman Oh, Councilman Tolberberger, and State Rep John Taylor for finally taking some action to address this issue. Councilman Oh, you made one statement. I don't want to hold it against you, but you made a mention that this may be a problem that has lasted approximately a decade. I've been dealing with this issue for many decades. I've been around for a while, and I represent landowners who have had to suffer through this problem. People breaking in to an unoccupied property and setting up shop. Anyone who breaks into a property has committed a crime. I understand your ordinance doesn't address the criminal aspect of this. I can assure you that the civil courts do not adequately address this issue. This is not a situation, and your ordinance does not address legitimate tenants who occupy a property. It does not address someone, sadly, who may be the victim of domestic violence, because that individual, generally or ordinarily in the confines of this argument, is a legitimate tenant. This addresses an unscrupulous individual who has somehow or another managed to break into someone else's real estate. The process through the Court of Common Pleas currently can take upwards of a year, even longer, depending upon the circumstances. The financial burden on the legitimate owner who has done nothing wrong is obscene. Not that my fees are obscene, but the whole idea of what is going on. And more importantly, or perhaps just as importantly, we're dealing with possibly the theft of water and sewer, or water from the city of Philadelphia, the theft of PGW services, the theft of PICO services, certainly the potential for violence where a legitimate owner comes upon his or her own property and finds an unauthorized occupant there, where the police obviously don't want to get involved and or won't get involved, and now what is one to do under the circumstances? This is not something that promotes some sort of unfair action or tactics against legitimate tenants. It does not protect the unscrupulous owner who comes forward and says, hey, someone broke into my property when in fact there may be a legitimate tenant. I think we need to have the safeguards that have been suggested. I think there's a procedure that needs to be put in place. I think we need the cooperation of the Court of Common Pleas to entertain expedited hearings. Again, we're not talking about municipal court, which is the court of initial jurisdiction over landlord-tenant relationships. This is something far outside the landlord-tenant realm. So I appreciate the opportunity to be here. And couple other thoughts, and that is what sometimes falls through the cracks is that these situations lend itself to a declining or eroding tax base and a declining, eroding housing stock. So the very people who might benefit from having safe, secure properties, these are properties that end up being destroyed, pipes being removed, all the way down the line, all these different problems, and it does not help the city of Philadelphia a little bit. Something needs to be done. Thank you. I appreciate the opportunity.
Thank you. Thank you for your testimony. Any questions? Anyway, thank you very much for your testimony today. Thank you for waiting, too, for your patience. Thank you. I'd like to call the next panel, Don and Debbie McGee and Matthew Wyckoff. In the efforts of time, I just want to remind everybody, we'd like to keep the testimony to 2 minutes. You need to state your name and if you're testifying on the bill or the resolution. So how about if we get started with Don and Debbie McGee?
Don McGee. Hello, everyone. I'd like to thank everyone for their time and work on this matter. We lived in our house on Akron Street for 30 years. Deb and I finally raised our kids and wanted to move forward. We put our house up for sale. We had an agreement of sale. We have buyers coming in doing inspections. They go to our house one day. The house sign is kicked down. Doorknob being changed as we're there. Lockbox taken off. I go downstairs, back door kicked in. Call the police, they arrived at the property. We have a lease, we belong here. It is so fictitious, it is ridiculous. Ridiculous. Officers tell us to go to landlord-tenant downtown. Wrong. Not the right place to go. Police officers tell us, leave your personal property there. You'll be able to get back in within a day. Wrong. So, we file motion, enter into the legal process. We write there's 10 people squatting in our house. 10 people. We entered into the legal process. Then we're told the DA's office can do nothing. License inspection, nothing. Police department, nothing. We finally hire a lawyer. Pay for it, hire him. Told to give him 20 days. Okay? All right, then there's another 10 days. And there's another service. I got to pay for another service, another 10 days. 150 days in now, they're still there today. We're paying the mortgage. We're paying the utilities. Lost the sale of our house. And don't know where the end is. There's no reason the burden of proof should be put on a legal homeowner. I had my license, I had utility bills, I had the deed. I was the owner of that property. No one else was given permission to be in that property. And they should not have been, and when the police were there, they should have been asked to leave, in my opinion. We just live with this every day now. Thank you.
Thank you. What was the address of the property?
5357 Akron Street.
5357?
Akron, A-K-R-O-N, Street, 19124.
Okay. We're going to come back to you. Matthew Wyckoff?
Good morning. My name's Matthew Wyckoff. I'm the owner of 1134 Wakeling Street. And
Microphone much closer, please.
yes, sir. So my situation was the impetus for bringing attention to this situation. I prepared a few slides. I shared them. They're now part of the record. I'll just give you a brief summary and yield a couple seconds to my lovely wife, Carla. Basically, I came to City Hall and spent a day knocking on doors, learning the process. So I started at the District Police. I went to the Northeast Detective Division, Court of Common Pleas, Proclamatory. I learned all of these city employees, 22 of them in the end. And each one of them is able to look me in the eye and sleep at night and say that, you know, I was doing things right. But at every door that I knocked, nobody could tell me that collectively the city was able to do the right thing. And that's what I'm hearing today, that your council is considering responsibly. What can we do differently? And I genuinely applaud that. And I'm willing to share from my experience all of the steps that didn't work. And I was fortunate. I was able to get the tenants out. But it wasn't because of anything that the city did. It was because of a loophole that one utility company was able to bring in the other, and we were able to resolve it that way. But that was because I started asking better questions, and I started speaking up more confidently, and so it wasn't a collaborative experience at all.
Hi, I'm Carla Wyckoff, and I'm also the owner of 1134 Wakeling Street. I'm a wife, I'm a mother, and I'm an employee who does home care in Northeast Philadelphia. I work in the 19124, the 19135, the 19149, all these areas that we're talking about. I go into the home and I help the medically disabled. I'm not going to talk to you like a lawyer. I'm not a representative. I'm not a statistic. I experienced this. I don't have to imagine showing up at my house with a stranger in it, because I did it. I stood on the street and I watched the police officer knock on the door and a woman come out and say, "Here's my lease. I live here." That police officer didn't ask her for proof. He didn't ask her, he may have asked her for her driver's license, but there were, multiple people, there were children in this home. They did not step foot into that house to see the broken window, the broken locks, the broken lockbox that were in that home 2 weeks later when I had to clean it. The law states that you're not allowed to self-evict, as one of you spoke earlier. So that person living in that home now had more rights than I did. My husband went when the home was empty and tried to change the locks back, and the people staying there called the police on him. And they were allowed back in the house, and we had to leave. The system is against me, but I'm not allowed to take matters into, I don't want to take matters into my own hand. But I've been violated by these people that came into my home. I've physically been violated because my home is now in, and as Mr. McGee, we had a contract to sale in that home that did not go through. And we now have a new contract to sell in that home for $30,000 less. $30,000 less than what the original contract of sale was. The way that I was treated by the Philadelphia Detective Department, I was disconnected from a call after I was asked that once I calmed down, then they would talk to me about it because I was crying. I was not cursing. I don't curse. I was not disrespectful, but I was crying. And I was told that I had to calm down before he could speak to me. I asked what the law was. Could you please show me a copy of this law that's keeping these people in my home? And I was told to Google it. That was the answer that I received from the detective department at the City of Philadelphia. I was also told by the sergeant, as Matthew said, we were able to get back into our home because of the electric company came. And I asked the sergeant what was the best way for me to prevent this from happening until I sold my home. And he asked if I had a license to carry a gun. Is this the solution that the Philadelphia City Council wants to these situations? This is not my solution. And just to give you a little picture, and I apologize that this might be graphic, but the things that I found in that home, there were used birth control items that I had to clean up off of that home. We were lucky that there wasn't physical damage that financially caused damage to that property, but having to go into that home and clean up this mess was what we were dealing with. I just want to thank Councilman Oh, because your statements, Senator John Taylor, Mr. Barrett, they really explained what's happening here. And there is a clear criminal crime happening when there's a broken window and a broken door. And I think that the purpose of this hearing is to provide a clear indication to the police what they are allowed and what they are not allowed to do, so that people like Mr. McGee and myself are not put in this situation that has affected us financially and emotionally for an indeterminate amount of time. Thank you.
Thank you very much for your testimony.
I just wanted to have a...
Go ahead, Councilman Tolberg.
Thank you, Mr. Chairman. A quick comment, because I think the testimony's been powerful. Both Mr. and Mrs. McGee have been in my office, and Mr. Wakehoff has been in my office, and I wanted them to come here today to explain in how they saw it, the difficulty they went through when government doesn't work. And to be very direct about it, I'm glad you came, because in the future, maybe this can be resolved. I'm going to work with my colleagues to get something that works for the homeowner, the person that put out all the equity, the sweat equity, the dollars, to keeping their home up. Because when it's all said and done, these are the people that play by the rules, and conversely, the rules ought to be there to protect them. So I can't thank you enough for coming, for letting us know of your frustration, because I knew it was a great one. Mr. Wakehoff, if I stood right in your home when the police were there the second time. It was a little different story then. But quite frankly, that was 9 days afterwards that we first made contact, and that was through State Representative Taylor. Your rights have not been upheld and have not been listened to by government, and it's about time they will and do. And you have my assurance that we were going to craft some legislation that really will work and work well. Thank you for being here.
Thank you, Councilman. I have a few comments or questions I wanted to ask you. Your house is currently sold right now? It's
Nope.
not sold.
We're still awaiting closing.
Waiting closing, you're pending closing, but no one's living in there now.
Correct.
It's empty. Your house has people living in there as we sit here today?
Squatters are still there.
They're still there after 150 days.
That's correct.
What are we doing about that as a city? I see some city people in the back.
Having hearings.
You guys want to comment about that? I'd like to know what we're doing as a city that someone has someone illegally living in their home for the last 150 days, which is deplorable.
Nothing.
Well, we're going to hear some comments.
Mr. McGee, my name is Mike Barry from the DA's office. This is Mike Barry from the DA's office, back up on the record. Councilmember Dom, I am not aware of this case being referred to us. I actually, as this testimony was going on, all arrest warrants get emailed to me, so I searched the address, and there isn't a pending warrant for it right now, but I have every intention of speaking with Mr. McGee as we leave chambers and doing what I can to get this resolved as quickly as possible. Although I would also note that both knowing my situation with Councilman Oh and the situation that these folks went through, it seems to only get resolved when somebody leans on someone. And again, that sort of points to the issues at hand here. I'm very willing to help Mr. McGee on his way out of here and speak to Northeast Detective Division to get something done as quickly as we can.
But as a city, we need to do everything we can to help. This is unacceptable, 150 days, unacceptable. It's ridiculous. So whatever you can do to help, we would greatly appreciate.
Chairman, I have my light on.
Councilman O?
Thank you very much. Mr. McGee, it's been over 5 months since someone literally kicked in your door, changed the locks in front of you, took down your for sale sign, took down the lockbox while your personal items were in the home. I will say that you came to see me as well. 3 weeks ago, I put in a request to meet the Commissioner of Police and the District Attorney. I very much thank the District Attorney for meeting with me about the pastor's case. Unfortunately, I was not able to get a meeting. I hope through this process we'll get a meeting because I have also heard in my conversations with the District Attorney's office, wonderful person, sharp police officer, now working for the DA's office, that if a criminal burglary, as in your case, is not pursued within a matter of weeks, it becomes a civil matter. And I said, wow, could you tell me who taught you that, where you learned that? And the officer said, well, actually, nobody told me that. I never read it. It's just something that I assumed or I understood. We get very, very little instruction. And I let her know a crime is a crime until the statute of limitations ends. And so there is probable cause for sure that a crime of burglary, criminal trespass, and fraud was committed in your case, and that an arrest warrant should have been issued 5 months ago. The police should have come out to your home and arrested the people in your home, and you should not have had to gone through this process at all. And the same for you as well. This is just a horrendous dereliction of duty. And I hope through this process, we will be able to address this, and I would say that there is no reason to hold this bill, my bill. I understand people want to do good. I would say that when you start advocating for the criminals that are victimizing the homeowners of our city, you do a great disservice to those innocent people, and you do a tremendous disservice to the cause of helping people who need homes. And we are already a very tenant-friendly city. That's fine. But advocating for criminals in these obvious cases certainly will not do you well. Thank you.
Thank you, Councilman. On behalf of the city, we apologize for what happened. We're going to try to fix this going forward. You're going to meet with the representatives from the city after this hearing. I'd like to hear what happens about that, and hopefully your sale will go through. I'm sorry for that loss. I'm not sure what we can do, but we are very, very sorry to hear this. This is terrible. This is not a shining moment for Philadelphia to hear these stories. But thank you for your testimony today.
I just want to say that the people that were removed if you want to put it that way, from our home, showed up 5 blocks later, 3 days later. So by not removing the criminals, you're just repeating the cycle.
Is that the person that's in this package you gave us?
Yeah, the crew that was in our particular house showed up 3 days later in a house 5 blocks away. So
Not theirs.
we wanted to make that part of the record. And then another aspect that hasn't come up today that I think is worth mentioning is my particular property is the highest property value in the zip code. And so when I do sell, it will be the comparable for the foreseeable future. And now it has taken a 10% hit. And it's a direct, tangible result of this particular situation. And so that's important to note.
Mr. Rakoff, are those people still in that other home?
It's on Dyer Street, and I haven't paid attention. I apologize. I
That's
believe
okay.
they are, actually.
I believe they are. Okay, well, that's
Councilwoman
important
McCammon?
information.
Yeah, I just want to, again, reiterate the chairman's remarks about how sorry we are for what has happened, and also that, I know you have great advocates here on City Council, but all of us will be working and talking with the Northeast Police District, and certainly with the DA's office, because clearly this is criminal activity that is moving on far beyond the scope of, that should be covered under existing legislation, and we'll make sure that it's something that gets addressed right away. So thank you very much.
Thank you for coming down and testifying through this difficult situation, and hopefully your sale will go through. We're going to work to get these people out of there for you. Thank you very much. Thank you.
Thank you.
Appreciate your time.
Our next panel is James Walter, Joseph Sanuti, Jeff Barg, and Maria Vicente. I can't believe they're still there for 50 days. Wow, it's awful. This is ridiculous. That's beyond my comprehension. Thank you for your patience today and waiting. I guess we'll start with James Walther. Just state your name for the record, and if you're testifying on the bill or the resolution, and we're trying to keep this as close to 2 minutes as possible, you can do a summary. Thank you.
Good morning, council members. Thank you for inviting me to testify regarding Bill number 170827 and the accompanying resolution 170841. My name is James T. Walter, and I'm here to testify about the inadequacy of the judicial process to eject illegal occupants from properties in Philadelphia. A little background, I'm an attorney at a civil litigation firm in Center City, Gildale, Kramer and Associates. Our office handles a number of real estate matters for our clients, including ejectment matters and landlord-tenant matters. Recently, while working on an ejectment matter that is currently pending in the Court of Common Pleas, we became aware of issues with squatters who trespass.
Excuse me, can you pull the mic a little closer?
Sure.
Thank you very much.
Recently, we were working on an ejectment matter, and we became aware of issues with squatters who trespass and use forged documents and other methods to abuse the judicial system. These squatters can live rent-free for months, sometimes years, at the expense of tax-paying property owners. Under the current system, civil ejectment proceedings are too lengthy to adequately address these situations and can be extremely damaging to the legal owner of the property. In the situation we encountered, our client was in the process of selling a property under a contract to sale. The sale was supposed to close by the end of June 2017. Our client received a letter in early June from PECO saying that someone changed the electric service from his name. He investigated and found a squatter on the property. Our client informed the squatter they weren't permitted on the property and they needed to leave. The squatter refused to move. Our client called the police, who arrived while no one was home. The police filed a brief report, but did not investigate the matter. Our client had started an ejectment proceeding against the squatter, and to avoid a judgment on the pleadings in that proceeding, the squatter, months later, produced an alleged lease with the forged signature of our client and also bearing the name of the second squatter and a non-existent LLC. These same squatters were ejected from a property down the block from our client's property less than a month before he found them occupying his property. That preceding ejectment from a neighboring property was filed in March of 2016, and an execution of judgment wasn't granted until May of 2017. The squatters in that proceeding then sought reconsideration of that judgment and a stay of execution in order to prolong their occupation of the property. In the current matter, which is still pending, the court held a case management conference at which a date for trial and other deadlines were set. Because the serial squatters claim that there's a lease in our case, the court treated this case as a contract dispute and placed it on an expedited non-jury track for 8 months from the time of the case management conference. The trial is scheduled for July 2018, over 1 year from the unauthorized occupation of the property, and about a month from the end of the alleged lease term in the lease with the forged signature. The timing of the judicial process in ejectment cases is inadequate to address these situations and protect property owners. A victimized property owner has to wait months, even years, and incur significant costs to access, rent, or sell property they legally own. We believe that a system that provides a prompt, efficient, and fair resolution to these situations is necessary and will protect the rights of all parties. Thank you again for the opportunity to testify, and I'm happy to answer any questions.
Thank you. Joseph Sanuti?
Yes, good afternoon. My name is Joseph Sanuti, President of the Tacony Civic Association, and testimony for Resolution 170841, Bill 170827. As I said, I'm the President of the Tacony Civic Association, which was started in 1982. Squatters have negatively impacted the community for as long as our organization has existed, if not longer. When squatters illegally occupy a property, there's a ripple effect which takes its toll not only on the property itself, but an entire neighborhood. The safety of adjacent properties and the quality of life on a given block are immediately compromised when squatters move in. There is a considerable risk to the owner of the property if he or she attempts to assert their rights, and more so to adjacent occupants who have to deal with this on a daily basis. Neighborhoods like Tacony are especially vulnerable to be impacted by squatters, as the 15th District is one of our largest and busiest districts in the city, police districts, and it seems this is exploited by those who want to occupy a property illegally. The city's police department and license and inspection departments are overwhelmed with issues considered more pressing than squatters, and many times the problems are left to fester for months, if not years. The last case we had in Tacony was on Friendship Street, forced neighborhood volunteers to seal the property in order to restore a decent quality of life in the immediate area. I raised my hand. There's no reason that we should be expending this kind of time and resources, not to mention exposing ourselves to considerable risk to deal with a problem which is now being well addressed through this bill. We in Tacony are also subject, especially in colder weather, to a heightened risk of fire in homes occupied by squatters. Ours is a densely populated area with a large percentage of attached row homes, many of which were built prior to 1900. Some neighbors of squatters' occupied properties grew so weary of coexisting with the situation, they chose to move from the neighborhood, and many in cases out of the city altogether. In order to maintain neighborhood stability, Councilman Oh's proposed bill should be passed as soon as possible in order to get a grip on the squatters' problem. Councilman Oh's bill will allow for a more expedient and transparent process for dealing with squatters, one which will help and keep good, hard-working families in the neighborhood instead of being forced to move out. The misconception that there are squatters' rights has led to a passing the buck mentality among city agencies, which are better equipped to deal with this issue than community activists, whose time could be spent better addressing activities and programs sponsored by their respective organizations. Neighborhood stability is directly related to a morale. Many of us in Tacony are very proud of our rich history and fine architecture. Pride in place has been fostered through many years of events, promotion, and educational relating to our industrial heritage. I have one question for Councilman Oh. We spoke about people landlords who own these properties. How about vacant properties where the landlords are gone, the people are just, they left, and the property is just sitting there in blight, and the squatters move in, but there's no actual owners? What happens there?
My bill does not cover that situation. That is a situation that is dealt with either by the Crimes Code or LNI. My bill, because that is an abandoned property, my bill does not cover that situation. So my bill deals with a situation where there's a lawful homeowner or owner of the property that has not abandoned the property, although it may be for sale. It could be a developer, someone's fixing up the building. So because my bill is a ordinance that has to do with a civil situation, it does not cover abandoned or vacant buildings. That would be another bill.
Oh, okay, so stay tuned, okay.
Yes, but thank you.
Thank you for your
Thank you,
testimony. I'd
thank
like
you
to
for
call,
having us.
Marie.
Thank you for taking the time, very much so.
Any questions for me?
Maria Vicente.
Good morning. My name is Maria Vicente. I have been working with a private investor in the city of Philadelphia for the last 17 years, going on 18 years now. Excuse me. We deal with rentals throughout the entire city of Philadelphia. Just recently, for my very second time in 17 years, I discovered a squatter situation that I could not handle on my own, meaning that I went to the property, I told them who I was, what my position was, I showed them documents including a deed and a HUD, who the property owner was, I showed them a copy of my power of attorney showing them who I was to the owner. Normally, when I come across a squatter, I've been lucky enough that the squatter actually realizes that I'm not going to go away, that we're going to take action, and within a few days, they vacate the property. This time, it did not go that way for me, and I ended up calling the police because it escalated to a very hostile environment where I felt my life was in jeopardy. When the City of Philadelphia Police Department came out, I had a woman police officer answer my call, and she told me that I should have never knocked on the door and showed them anything, that I should just went away and went and filed in the municipal court. I informed her that I was one of the first lay people to be picked in municipal court to file my own evictions, as attorneys do, through the electronic filing system, and that was incorrect, that municipal court could do nothing to help me. I thanked her for her time and asked her if she could possibly bring another police officer to the scene. She did. Another police officer informed me that as much as he would like to, that there's nothing he could do because there is a squatter rights law in the city of Philadelphia. I assured him that I knew for a fact that there was not, that I had Googled and did all of my research, and there was no such protection for people who obtain illegal residence in someone else's dwelling. We had another 15-minute conversation. At this point, the property owner showed up because he happened to be on the phone with me and was concerned for my safety when he heard the exchange of conversation in the background. He assured them that he was the owner, he showed his ID, and he thought that that was the solution to the problem. He was also informed at that point in time that there was nothing they could do to help him, and that there was nothing he could do at that point other than go to municipal court at 1339 Chestnut Street, which again is incorrect. It would be an ejectment. It would be through the Court of Common Pleas. The very following day, I began the ejectment process. The complaint is quite long, and there are lots of procedures in time that have to be filed in a timely manner to even accomplish this. I called PGW and let them know that the services were on illegally because I didn't want my name to be involved in the fact that there's a property that my name is attached to and there are illegal services. I did the same with Pico Energy, and I did the same with the water department. They all let me understand that my problem was one that needed to be handled at municipal court and that I needed to go file an eviction, that they can't turn utilities off. They'd have someone investigate it eventually. 3 weeks to the date of that actual initial complaint and filing of the ejectment, I served all the paperwork, did everything I was supposed to do. There's a detective now involved because the person claimed that they were scammed, which there's been no evidence to justify that yet. I went back out to the property 3 weeks to that date, and I knocked on the door again, hoping to be able to reason with the person who lived there. She had little kids in there. They were living in conditions of a building that was under construction. It wasn't safe. I wouldn't want to see any human being live like that. So I went out and I tried to speak with her again. I was pretty much told I could go take a flying leap off of a building, and that she knew for a fact that it would take me months and maybe a year before she'd have to leave there, and good luck to me, and I could come visit whenever I wanted. At which point I was quite heated and I made myself leave the property before I crossed to a path I didn't need to go to. I started posting notices on the door every single day. By this time, I actually gained the ability to have the utilities legally disconnected. Now the tap is cut for the electric up at the street, which means that the owner of that property will have to pay $500 to get that reconnected. PGW's been cut at the street. He will now have to pay to have gas service legally placed in that property again. After all of my notices and my, I guess, as she put it, she actually told the police officer I was harassing her, which I found quite interesting. They finally left the premises. I got lucky. The last squatter case I had, 14 months later, before they left. The damage to the building was so bad that a year later, the house is still under construction. They took every plumbing, they used toilets where there were no plumbing, they used the tub as if it were a toilet. The place was flooded, radiators were cut, gas lines were cut. I can't begin to tell you the amount of damage that was done at that property. We absolutely have to have Councilman Oh's bill put into motion quickly, sooner than later, because I am a reasonable woman and I do this to make a living. This is how I feed my family. So this actually inhibits me for gaining income to feed my family when we have squatters be able to have this kind of control over legal owners and agents. I can't stress, I am so grateful for everyone here today, even taking the time to listen to all of us and knowing that our city is finally moving in a direction where we're noticing what a serious problem this is, and something must be done immediately. Our City of Philadelphia Police Department does not know how to help us because they don't think they have a right to help us. The first thing we need to do is a bill, make it clear, yes, this is trespassing. No, they are not a tenant. They're here illegally. They broke and entered no differently than if I were in Wawa and I was asked to leave and I didn't leave, I'd be arrested on the spot.
Okay.
Thank you for your time, everyone.
Thank you. One quick question.
Sure.
Where was the property located that you
It was located at 6927 Pascal Avenue. It is a duplexer. And this particular property owner owns about another 100 properties throughout the city of Philadelphia.
Okay, thank you very much.
You're very welcome, sir. Thank you for your time.
Thank you. Jeff
I'm going to
Barr.
excuse myself. I have a hearing in municipal court in 15 minutes.
Okay, thank you.
Thank you.
Thank you. Good afternoon, Councilman Dom and members of the committee. Thank you for the opportunity thank you for the opportunity to offer testimony on Bill number 170827. My name is Jeff Barg, and I am the Associate Director of Planning and External Policy Relations for the nonprofit Pennsylvania Horticultural Society. At PHS, we work every day to connect people with horticulture and together create beautiful, healthy, sustainable communities. Today, I wish to solely address the amendment that will be offered by Councilman Oh, which stipulates that in the context of this bill, gardens are exempt from the definition of, quote, real property, unquote. We support this amendment because we believe it will protect community gardeners who voluntarily maintain much of the city's vacant land despite not having official land tenure. In neighborhoods across the city, individual and community gardeners tend land, produce healthy and nutritious food for themselves and their friends and neighbors, and build stronger communities through gardening. While much of this gardening happens on land owned by the gardeners or by affiliated organizations, often gardeners end up maintaining vacant land that the city is unable to care for itself. We appreciate the measures that this amendment takes to ensure that gardeners will not be further penalized for their stewardship of vacant land. In addition, we would further support any action that City Council can take, whether through the Land Bank or other city departments and agencies, and in partnership with organizations like the Neighborhood Gardens Trust, to fully secure land tenure for our city's gardeners and growers. Thank you very much for your time.
Thank you, Mr. Barr. Thank you. Any questions? Okay, thank you for your testimony today. I'd like to call our next panel, which will be Dana Goldberg. I think Dr. Carolina Baltazar Harris has written testimony, and also Jennifer Schultz and Rashida Phillips. And I believe after this panel, we have 4 more people: Ebony Griffin, Francis Rose Sobiondo, Della Haskell, and Phil Lord. Did I miss anybody in the audience? Okay. Why don't we get started with Dana Goldberg?
Thank you, Chairperson Dom. Councilman Oh, I appreciate the opportunity to testify here today. I have submitted to the council written testimony, which I may, for purposes of brevity, shorten a little bit here. I appreciate the opportunity to highlight our concerns over the newly proposed legislation governing treatment of persons classified as squatters. Our work at Senior Law Center is protecting the rights of older Pennsylvanians. Located here in Center City, Philadelphia, we were founded in 1978 to protect the rights of seniors in need and now serve over 5,000 seniors each year between the ages of 60 all the way up to over 100. We save homes, prevent homelessness, fight for grandparent rights, stop elder abuse, fraud, and exploitation, and promote independence and dignity. We are an independent nonprofit and the only nonprofit organization solely dedicated to providing legal protection to Pennsylvania senior citizens. Whether more seniors will be protected by the proposed legislation or harmed by it is debatable. Seniors intimidated by persons who occupy their homes without permission and refuse to leave may be protected if the police come to the home and order the squatter to leave. However, seniors are just as likely to be on the receiving end of the police order. If the property has been stolen from the senior by way of deed fraud, currently an epidemic in many Philadelphia neighborhoods, once the thief records the deed, he can also summon the police to order the senior from the home. Also, as more seniors lose their lifelong homes as the result of mortgage and tax foreclosure, under the proposed legislation, a purchaser of the property at share sale can have the senior ordered from the home with 48 hours notice. 48 hours is not enough time to find a senior suitable housing in a safe neighborhood, to pack up a lifetime of possessions, to notify friends and family and the post office of their new address, to forward prescription medications to a new pharmacy, to notify banks and Social Security, and the list goes on and on. These seniors will also need help from the city-funded Housing Counselor Network to find housing and make the move. The ability to act promptly to remove an interloper or squatter is important. However, care must be taken that legislation is not written so broadly that the unscrupulous person can easily take advantage. Consider a scenario where an owner and occupant have an oral lease which creates a landlord-tenant relationship. If rent is paid in cash without a receipt, there will be no written proof that the occupant is a tenant. If the tenant does not live in the property long enough to receive mail or submit change of address forms, she or he may be subject to being labeled a squatter due to the inability to provide proof of legal residence to the responding officer. Potential gaps exist in the bill as written, which gives us pause. We welcome any opportunity for greater collaboration with our city's leaders in law enforcement, in this council, with the mayor's administration, with all other government and quasi-governmental agencies in the city, as all should be highly concerned about the health and welfare of our seniors. Senior Law Center would like to work with City Council on amendments to this administration, which will ensure that all seniors will be protected. Senior Law Center supports the protections provided in Bill number 170827 and the creation of a rapid police response in the limited instance where a threatening person occupies another's real property without proper authority. However, we have concerns for seniors whose homes have been foreclosed or stolen, and for those seniors who are rightful tenants but may have an oral lease and the effect this bill will have on them. A senior homeowner currently must file an ejectment action to procure the proper court order to remove a third-party trespasser from the residence. This process can take anywhere from 3 months, usually when a default judgment is procured, to 9 months, when a full trial is required. During this time period, the third party remains in the senior's home with the senior present often. In a growing number of these scenarios, the illegal occupants are intimidating the seniors and often exploiting the seniors financially. Where no intimate or familiar relationship exists, and where threats of violence or actual physical harm has not yet occurred, the senior is unable to file for a protection from abuse order. The senior is left to wait in the same household in an often increasingly unstable and unsafe environment. We welcome a more expedited process for our senior homeowners which protects them from harm from unauthorized persons residing in their home without their permission, or those seniors whose homes have been stolen through defraud. However, the current bill paints with too broad a brush. Senior homeowners whose homes have been foreclosed and seniors who are rightful tenants need the protection afforded by the ejectment and the eviction process. We need your partnership and support to make this city one that truly demonstrates respect for our elders and their safety, dignity, and well-being. We look forward to working with you to make Philadelphia a safer home for our senior population and to empowering our senior citizens in their fight against exploitation and abuse. Thank you.
Thank you for your testimony. I don't believe Dr. Harris is here, so written testimony, yeah. So let's go to, is it Rashida Phillips?
Yes. Good morning. Good afternoon. My name is Rashida Phillips, and I am the managing attorney of the Housing Unit at Community Legal Services of Philadelphia, which provides free legal advice and representation to over 2,000 low-income tenants living in private and subsidized housing in Philadelphia each year. We are grateful to have worked with City Council for several decades to protect tenants and promote safe, affordable housing. Thank you for the opportunity to testify on Bill number 170827 and Resolution number 170841 at this public hearing. Just a few months ago, in March of this year, I testified in this chamber regarding Philadelphia's eviction crisis. We're now alarmed to see proposed legislation that threatens to increase the number of illegal evictions and the number of homeless families in our city. The resolution is clear that the underlying issue of concern is brazen criminal trespass by fraudster squatters. We agree that there is a need to address that issue. However, the proposed bill would do much more than address trespass or fraud and threatens to increase the number of illegal lockouts of legitimate tenants. CLS supports the resolution's recommendation for hearings and an analysis of the need for any new legislation beyond existing laws regarding trespass and fraud before any bill moves beyond this committee. CLS will be happy to participate in a task force or similar effort to study these issues and to recommend solutions. However, we urge this committee to hold the proposed bill until the issues are reviewed further. In our daily contact with tenants, we regularly encounter instances when an unhappy landlord uses the word squatter to describe tenants who do not move out right away when demanded by the landlord. The lease may have recently expired, which creates a holdover tenant and not a squatter, or it is possible a new owner has entered the picture, having purchased the property along with the lease, and mistakenly believes that the existing tenant is a squatter. Further, month-to-month oral leases are very common, as you've already heard, leaving the tenant with no document to prove tenancy, or a tenant is legitimately withholding rent due to conditions in the property. Under this bill, however, these legitimate tenants could be characterized as squatters and put out on the street if written leases, rent receipts, or other evidence cannot be quickly produced enough for the police, or if they're locked in the house or elsewhere. A typical case in our office involves a tenant who has paid a deposit equal to 2 months or more of rent, moves into a property, and then soon experiences plumbing problems, leaky roofs, no heat, or other need for repairs that are the landlord's responsibility. Under Pennsylvania law, tenants may withhold rent in certain circumstances when a landlord delays in making needed repairs. These very tenants are often then called squatters by upset landlords. City Council has proposed or enacted a number of important provisions to protect renters under these circumstances, and this bill would allow unscrupulous landlords to render them hollow. Under this proposed bill, if these tenants do not have a written lease or rent receipts to show police after an owner calls the police to remove them for being squatters, they will become homeless. The bill could also hurt victims of domestic violence by giving abusers a way to assert control over their victims. It is not uncommon in situations of domestic violence to have the property in the name of the abuser only. The victim may have few, if any, documents linking them to the residence, which is a symptom of the abuse itself, perhaps because the abuser hid or destroyed what documents existed. Under the bill, an abuser could merely call up the police, allege that the victim is a squatter, and the police would have no option but to remove the victim. Criminal trespass laws and common law fraud claims are already options in place to penalize the fraudster squatter. The bill proposes a severely expedited law enforcement process to remove so-called squatters in place of a legal process with due process protections. The police are unsuited to perform what is essentially a judicial role. They would have to have many hearings and evaluate testimony and documentary evidence. This is not a role for the police. It is a role for our courts. It has been suggested that the current court procedures for ejectment cases are too cumbersome for parties who do not have lawyers. We agree that litigating a case without an attorney can be daunting. We see this every day as low-income people from all over the city apply for legal services. However, the solution is to help to make the court process more user-friendly, not by eliminating due process and relegating tenants' rights to quasi-hearings on a sidewalk with the police. CLS is eager to help with efforts to create forms or other educational materials that would make the courts more accessible. It has also been suggested that the legislation be enacted to prohibit oral leases from being created or from lasting beyond 2 or 3 months in order to address the difficult oral tenants have of proving their tenancy. We believe that such a change will be counterproductive. Many parties will still enter into oral leases and continue with the oral agreement after the 2 or 3 month period ends, notwithstanding the changes in the law. This change unfairly skews the balance of power between landlord and tenant. It would allow landlords to deny the legitimacy of the tenancy if there is no written agreement and claim that the occupants are trespassers or squatters, even if the occupants took possession by agreement. At the same time, it would give tenants no ability to demand a written agreement. Finally, we believe this change will undermine the city's illegal lockout ordinance. Often, an eviction will occur by the landlord threatening a tenant so that they move out, changing the locks without a sheriff or a landlord-tenant officer, using force, removing the tenant's possessions, turning off the tenant's utilities, or otherwise rendering the property unlivable. The illegal lockout ordinance prohibits eviction without a court order, imposes a civil penalty, and encourages restoring possession to the tenant. This legislation would make the illegal lockout protections more difficult to enforce and puts the police officer in a position to have to determine on the spot whether a tenant is a squatter or is being illegally evicted. We should review these issues further as recommended in a resolution and not move forward a bill that could exacerbate an already troubling homelessness and eviction crisis. Thank you very much for the opportunity to testify. We look forward to working with City Council to further address these issues.
Thank you for your testimony.
Thanks.
I think next is Jennifer Schultz.
Thank you. I have submitted longer remarks in writing, but for the sake of time, I will do a brief reversion in my spoken testimony. My name is Jennifer Schultz. I am a senior staff attorney in the Homeownership and Consumer Rights Unit at Community Legal Services. To reiterate what my colleague Ms. Phillips said, CLS supports Resolution 170841. But we also urge the committee to hold on the proposed Bill 170827 until the issues are reviewed further. In our daily contact with homeowners, we routinely encounter instances where an unhappy party in a dispute uses the term squatter to describe a person whose rights they choose not to recognize. We see people who will even go further and make false statements in sworn documents in courts to try and further their position. They will often seek to enlist the police in their efforts to accomplish a self-help ejectment. Fortunately, current policies and practices prevent the police from getting entangled in a civil dispute. The proposed bill would upend this process and could leave many legal and equitable owners being forcibly ejected from their properties by the police with practically no notice. And many of the homeowner victims who testified here today would not be protected by the proposed bill because a forged lease would overcome the presumption of a squatter situation. The bill also oversimplifies the concept of ownership and equates a recorded deed with complete and legitimate ownership, along with the immediate right to possess a property. None of these ideas is correct. Deeds can be forged. Long before the current criminal trespass problem, Philadelphians have faced the problem of fraudulent conveyances. Forged deeds are regularly filed with the Recorder of Deeds office. Our current legal system provides a fraud victim with the right to challenge the legitimacy of a deed in court before they are removed from their house. Rights of possession can remain after sheriff's deeds. The existence of a recorded deed does not mean the record owner has the right to possess the property. When a house is sold at sheriff's sale for unpaid property taxes, the former owner retains a right to redeem or buy back the property for 9 months after the sheriff's deed is created. During this redemption period, the former owner also retains the right to possess the property. Deeds can also transfer less than full ownership. Ownership is a bundle of rights which can be parsed out and divvied up among different people. A deed can convey less than full ownership of the property. An individual co-owner can transfer their portion of the property without other co-owners. The most recently recorded deed would only show one of the owners of the property. A full title search is required to understand the full ownership picture in real property. Rights in real property can also transfer without a deed. Approximately 14,000 homes in Philadelphia are titled in the names of dead people. These people still appear as the record owners, but the legal owners are their heirs. Pennsylvania law has codified this principle that has existed for centuries in Title 22 of the Consolidated Statutes, Section 301B, where it says, quote, "Legal title to all real estate of a decedent shall pass at his death to his heirs or devisees." In heated disputes of families, it is not uncommon for warring sides in an inheritance to throw around the term squatter and seek assistance of the police to remove family from a house. Gathering documents to demonstrate homeownership can take time. How does one prove that they are an heir? It requires documentation of the familial relationship. At its simplest, that would require the long-form birth certificate showing the parent's name, plus a death certificate demonstrating that that person is deceased. In more complex cases, it could require dozens of birth and death certificates to fully connect an heir with their deceased relative. It is not common for people to have these documents readily available. It can take weeks to obtain copies from the Department of Vital Records. These requests can be complicated further if a requester does not have their own identity documents in order. As an authorized requester, Community Legal Services is able to help people navigate these problems, but it can still take up to 2 months to secure proper documents to demonstrate a legal right in a property. And these scenarios are not hypothetical. We have clients that have faced each of the challenges that I have listed above. And the complexity of these rules of ownership often escape lay people. Just as it has been suggested that the current court procedures for ejectment are complicated for parties who do not have attorneys, expecting lay people to formulate their own defenses is even more challenging, especially when the party leveling the accusation has had an unlimited time to formulate their accusation, but the person under the bill, the person defending against the accusation, would only have 48 hours. A savvy accuser would merely wait until 4:30 on a Friday afternoon to call the police. The opportunity to seek legal counsel at places like Community Legal Services and our sister organization, Philadelphia Legal Assistance, is key to the people's ability to effectively present their ownership claims and secure supporting documents. Improving access to justice is an issue that all members of the legal community take very seriously. Efforts are underway each day to make the system more navigable for laypersons. Just last week, in collaboration with the Court of Common Pleas, I trained over 100 attorneys who will be volunteering their time at the Civil Resource Center in the coming months to assist individuals dealing with ejectments. Thank you for your opportunity to testify today, and we look forward to working further with City Council to address these problems. And in closing, I would like to leave you with a recent quote from Council President Clark. "Government should be in the business of ending forced displacement and homelessness, not contributing to it." Thank you.
Thank you all for your testimony. Thank you. Councilman Oh?
Certainly. I'll address all three simultaneously. I appreciate your advocacy for the homeless, the low income, and the tenants. However, you have crossed into advocating against innocent homeowners who are being victimized by criminals. The police, every day, the police are the only entity, the only officials who are authorized to determine probable cause that a crime has been committed. I'm a councilman. I can't do that, and you can't do that. The police determine probable cause. They don't know all by themselves. They determine probable cause in conjunction with detectives, and then they submit it to the district attorney's office. The district attorney's office has a charging unit. The district attorney's office may decline charges or may approve charges. Then the court has to determine whether the charges are sufficient to bring a trial, and then it is beyond a reasonable doubt. This bill, however, doesn't have to do with any of that. This bill has to do with the fact that here in Philadelphia, if the police determine that the probable cause, there's not sufficient probable cause, we leave it to a court to determine whether or not there's an expedited process. There's no railroading anybody, and the judge can set it back or not. The only thing that happens if a police officer finds that there's probable cause to arrest, they don't arrest. They could, but this bill gives them the opportunity, much like the executive order we have regarding marijuana, rather than to arrest the person, which is the state law, to offer them a $25 fine. Here, this bill simply provides that the police, instead of arresting them, can simply give them 48 hours to vacate. Otherwise, if they don't get arrested, they begin to accrue a $300 a day fine. Now, if they are found in this expedited process or in a criminal court to have violated the criminal laws, to have committed fraud. So while I do appreciate the examples you're giving, the presumption that you are taking is in favor of the criminal. In other words, you have such an extent of precautions that in the McGee's case or the Wyckoff's case or Pastor Lee's case, you would have the police not take any action and there be no remedy other than going to 16 months possibly of a process that is hugely expensive and prohibitive to many parties. I am fortunate to I've visited about 35 senior homes and providers 2 years ago. I will be going to Texas to talk to AARP. The issue, I can assure you, at least from my anecdotal perspective, it's not any data, is that seniors are by and large a victim of these type of issues. And it's unfortunate because they are easy targets, because they are unable to speak for themselves, act for themselves. A case that I talked to someone about was a elderly woman at Broad and Tasker who was kind enough to let someone into her home, and she could not remove them. They just had to say, we're tenants. Now, I'm not saying that the deed and lawful ownership record trumps everything. I'm just saying the police officer, the detective, the DA, the courts will weigh the evidence that they have against the evidence, even if it's oral testimony corroborated by a relationship of being a tenant. If at any point these issues indicate you should be in regular court, you will go to regular court. But that woman passed away and her family came to her home to find 15 people living in her house. I guarantee you she did not die in peace. It took 16 months to remove those 15 people from this poor woman's home, and she was a senior. I am sure she didn't appreciate all these people in her refrigerator, in her home, watching her television. And so the balance that you seek, I appreciate. However, this issue has been around a long time. I'm going to push for my bill to be passed. I'm happy to work with anyone. As we heard from the horticultural folks, they told me, hey, this might involve gardens. We're not after gardens, nor are we after any of these situations. There will have to be a sign of a break-in. There will have to be signs that this was a criminal act. And if the police do not act, the court will have the opportunity to weed out those cases that should be in regular civil process. And listen, if a landlord wants to try to use this process, they subject themselves as well to fraud charges. If you have a rebuttal that you'd like to give me, that's fine. On the other hand, we've had people come in. I've had probably over 300 phone calls and communications on Facebook and others. I mean, I would say conservatively 300. Probably over 50 real-life stories of abuse and frustration. And so, to the extent that you are advocating for a group of people that you believe should be protected, I appreciate that. Once you start crossing over into the fact that in order to protect them, you are saying the police don't have the wherewithal or the ability to do their traditional job. And that is part of this problem. I am clarifying for them and giving them procedures in a civil context that there will not be confusion over this. Thank you.
Thank you, Councilman. I think Councilman Tobenberger?
Yes, thank you. A very quick to the panel, and I thank you for your opinion and your thought, and you actually coming down. So, Ms. Phillips, Ms. Schultz, and Ms. Goldberg, you've heard the Wyckoff and McGee testimonies, and they are probably only the tip of the iceberg. There are probably others that we have not heard of, that may not even know that they could come here. But I was going to ask you, because I think you have a sense of everything, you certainly put up valid viewpoints. How quickly, in the spirit of cooperation, working together, could you give us recommendations that would protect the Wakehoffs and McGee's to get to their justice, because you can see clearly they have been violated, and also to protect your constituency as well? How long would that take?
If I could just respond more generally, I think a lot of the stories that we've been hearing here today, I don't think any of us would suggest that those people are being treated fairly in our current system. The stories that we were hearing today are about essentially criminal theft of a home.
Correct.
And it seems to us that the appropriate remedy should remain in the criminal system. And the concerns that we have about the bill are not that we're trying to prevent police from doing their job. Police should do their job. But I think we're concerned that this bill goes beyond that point of a criminal trespass, and that the definitions in here, particularly the shifting of presumptions about who is correctly in a property, go beyond the context of the criminal violations and in the stories that we've heard here today. And so I think what we're asking is that any solution should be narrowly carved so that it's not stepping on the rights of people who are legitimately in properties. One of the things that I've heard over and over today is this idea of a forcible breaking, but that is not mentioned anywhere in the bill. The idea that there should be a demonstration of forcible breaking. I think things like that could be important. What I would suggest is that this is a complex problem that involves many different players in the governmental system, and having a task force in place where we can all sit in a room and talk about this and think it through and come up with measured and thoughtful solutions that involve all the players, the sheriff's office, legal services, the DA's office, the police. All of those players really should be consulted and come up with a shared effort. In terms of the individuals who spoke today, one of the recurring themes I also heard was that when they sought help, they were not directed to the right places. And I think that getting better education to the police, to the sheriff's office, to the municipal court, so that people are correctly directed when they deal with these problems is crucial. The police shouldn't need to have a law degree to do their job, but asking them to take on this task solely and individually is really more than what I think they're able to manage in the way that this bill is drafted.
Okay.
If I may.
Okay, please, no, go, and then let me respond.
So I'm the Director of Victim Services, and much of the work I do has to deal with those seniors who are abused and exploited. We do ejectment actions in matters where the safety is at issue with the seniors and we cannot find protections elsewhere. What I would like the council to be aware of is the law that it stands, and even in those cases where the defiant trespass is charged, the system is still very slow and is not resulting in the type of order, a court order that is required to have that person removed by the sheriff or the police department. The police are confused by the legislation that we have currently. And I do applaud council for taking up this issue to address a more expeditious manner of having illegal persons removed from a property. However, we do not want to sacrifice what we've worked so hard in this city to build, which is proper protections for people that are rightfully in a home. And in this regard, we as the Senior Law Center see both sides of the issue. We have seniors on both sides. I have seniors that are being exploited whom we can't get out for about a year to get the illegal persons out, but on the same hand, we have unscrupulous persons using these bills to try to get the seniors who are properly in a property out. So we need to have a dialogue and make sure, as Ms. Schultz had commented, that we are narrowly defining this to the definitions that we want to address. Thank you.
Thank you.
Well, the quick question was, how long do you think that would take to get some recommendations from you?
I would like
what would, you know,
I mean, I would like to have a dialogue if possible, so if it could be tabled for, I mean, I can't give you an exact amount, but I think an appropriate dialogue would be to bring the parties together, have a dialogue, propose the amendments, and then come back before the council with those amendments.
We have a point, hang on a second, we have a point of order from Councilman Oh.
As the author of the bill and the sponsor of the bill, I have been happy to meet with anyone who has any suggestions. I will move to have this bill out of council with a favorable recommendation. In the meantime, it then goes to a vote. If you have constructive input, suggestions, I am fully open to making whatever amendments would make the bill protect the interests that you're trying to protect without, at the same time, watering down the goal that I'm trying to achieve. So I certainly welcome your involvement. I will certainly urge that we do not postpone this bill, but I am certainly happy to work with you before we come to a vote. It can be amended between now and then.
Thank you. Councilwoman Kim?
Yes, so earlier, I think, had you worked on the task force around fraudulent deeds? Were you part of that kind of a task force?
Yes, I attended a few meetings of that task force myself. Also, a lot of colleagues at Philadelphia VIP were very integral in that group.
And I think that's a really great example of a situation where there's clearly criminal activity and behavior. There are breaks in the system that are not working. We need to figure out where those breaks are and then go in with a targeted approach as opposed to a blanket one. Does that sound like that's something that you were thinking through?
Absolutely. And having all of the relevant parties in the room and thinking through these problems as we discover them, and then coming up with solutions, trying those solutions, and then coming back to the table when they're not successful, I think is really what makes for a measured response that addresses all of the concerns of the parties involved, rather than simply, here's what I want, and that's the end of the conversation.
Thank you. Just on behalf of myself, I apologize for an earlier statement that was made and feel very strongly about the work that CLS, Senior Law Center, and PILCOP have done on behalf of the city of Philadelphia. This is a bill that the legal department has said violates the Pennsylvania state law around Landlord-Tenant Act, does not provide adequate due process protections, and subjects the city to substantial liability. The fact that people raise questions about such a bill that is being proposed does not automatically put anybody in the camp of defending criminal behavior. And I think that it is highly inappropriate for my council colleague to have accused anybody who comes before this body to testify about legitimate concerns that are made with a history that all of you have had around this work and are trying to figure out a way to make this better. So to me, it is very important that you don't feel like you leave this council in any way thinking that you have not been heard, that we do not take your issues seriously, that we do not respect you at the highest level, and that we do not in any way believe that you do anything else except stand up in the best interests of Philadelphia and our city, and I'm grateful to you for that. It is very important to me that we think through a lot of these issues and problems. It is essential that we do it with people who've been doing this work for a very long time. We heard earlier from our DA's office, obviously the representative, and from our representatives from the police department that they do not have specific experience around tangled titles, forged deeds, oral leases. They are not experts around landlord-tenant issues. Thus, having the three of you here who represent decades of work around that exact process is an essential component, and you should not be critiqued simply for bringing up those concerns. Your comments are welcome and embraced by myself on City Council, I'm sure by many others, and we do not appreciate anybody who would in any way accuse somebody of siding with criminal behavior. I just don't think that's appropriate. It doesn't belong here. We would like to move forward in a collaborative manner. So thank you very much for your time and testimony.
Thank you.
Thank you, Councilwoman Kim. I just want to make a statement. From what I've heard, I'm in the middle of this, okay? But from what I've heard is that everyone has the same goal in mind. So if we can work collaboratively together on this, we'll accomplish that goal. I'd like to recognize Councilman Oh.
Thank you very much. I speak plainly. I don't think I've said anything out of order. However, I clearly have stated my position. I've drafted a bill, and I put it forward. Regarding whatever positions you take, you are here. It's appreciated. To my colleague, Councilman Gim, I would say that you're entitled to have your opinion, to make your statements. However, this bill moves forward. You can vote against it if you like. Certainly, I will say again that separating and distinguishing criminal action from complex legal matters are something that our system needs to provide and has done. The police are trained, they are appropriate for this process, and they are the only entity that citizens can rely on, and they should handle this process. And in between that process, as there is confusion for some reason and a failure to act, my bill addresses that with a civil process. Thank you.
Thank you, Councilman. Thank you for your testimony today.
Thank you.
And thank you for your patience, too. I'd like to call the next panel. I believe Ebony Griffin, Harvey Spear, and Francis Rose Sobiondo. I just want to reiterate, if it's possible, we keep the testimony to 2 minutes. And it's 20 of 1, so I just want to keep that in everybody's mind. We still have about 8 or 9 more people to testify. So, Ebony Griffin, why don't we start with your testimony?
With who?
Me.
I'm going to start with Ebony.
Good afternoon. My name is Ebony Griffin. I'm a staff attorney with the Public Interest Law Center. I work to promote environmental justice and also lead our Garden Justice Legal Initiative, which provides pro bono legal support, advocacy, and policy research to community gardens and urban farmers in Philadelphia's communities of colors, immigrant and refugee communities, and historically disinvested neighborhoods. I planned initially to come and offer my support for Resolution 170841 and to talk about some of the concerns that I had that that bill number 170827 could potentially pose for urban gardens. Upon my arrival this morning, I learned that Councilman Oh planned to amend that bill to include an exemption for garden space. So that really addresses a lot of my major concerns with that portion of the bill. So in the interest of time, I've already submitted my written testimony. I'm not going to waste anyone's time on that.
Thank you very much. That was great. Mr. Spear.
Thank you for allowing me to testify on behalf of HAPCO. And my name is Harvey Spear. I'm president of Homeowners Association, which is known as HAPCO. We're the largest organization for the provider of low and moderate income private rental housing. HAPCO's membership owns primarily single-family and duplex rentals on the streets and the neighborhoods of Philadelphia. As we have seen reported in the news, the problem with squatters keeps growing in Philadelphia. Squatters currently occupy properties without rights or title, with very little consequence for doing so. Oftentimes, after a property becomes vacant, an opportunist squatter breaks into the property and begins to live there. Although they have no legal right to stay, the police will not force them to leave. The owner has to hire an attorney and file an ejectment action in the Court of Common Pleas. It may take many months and sometimes years to go through the legal process as it stands today. Essentially, the squatter has more rights than a tenant with a valid lease. Councilman Oh's bill is a step in the right direction, and HAPCO supports it. We applaud both Councilman Oh and Councilman Al Tottenberger in taking the lead on such an important issue. One minor request would be to amend the bill to allow the owner of a property to immediately be able to file an expedited hearing without first going to the police. There are many situations where an owner keeps the squatter, where owner knows the squatter is not going to leave, and requiring the police to go to the property before being able to file in court and may escalate the tension. Thank you for allowing me to speak on this important issue, and I'm available for questions. I just want to add that Personally, I have not had a problem with squatters in my ownership of properties, except for 25 years ago, where literally it was a disaster. I owned a property on Vine Street. I walked in and there must have been 20 people lighting fires. I walked in, I got chased out. Eventually the property caught fire and we had to demolish it. And I don't think anybody got hurt or anything like that, but my experience is one that I'll never forget from 25 years ago. Thank you for allowing me to testify.
Thank you for your testimony. Victor, you're going to testify?
My name is Victor Pinckney. I'm first vice president of HAPCO. Originally, I was not going to speak today, but after hearing testimony from both sides, we all seem to be after the same thing. But one thing that nobody's addressing, the time period that it takes to get a property back. That means that's one more house because most of this takes place in low to moderate income neighborhoods. The city of Philadelphia has a shortage of low and moderate decent housing. So now, and these squatters don't generally, they don't take the border, they go to a border place, but it's generally the ones that's being rehabbed. So that means that property is now off the market for anywhere from a year to a year and a half. That's all, so something should be done.
Thank you.
I just want to add, if it's possible, that it's not an easy solution, and we are not here to advocate anything to City Council. We're here to accommodate you and to try to come to a solution. I know it's a difficult one because the police have no way of knowing who somebody is. My leases are all written leases. I know with an oral lease something, it could be ambiguous. So we're not here advocating to throw this bill down everybody's throat. We would like to see a solution where it benefits everybody.
Thank you very much. Francis Rose Subiondo.
Good day. My name is Francis Rose Subiondo. I've been a resident of Southwest Philadelphia for the last 6 years. I came here also today to testify in support of community gardens. Hearing the amendment that gardens will be omitted from the resolution, thank you. Also, thank you for hearing my testimony today. First, I want to extend my gratitude for the decades of work, research, and experience that went into the last panel's testimonies. The research and testimony of all witnesses here today, truly much appreciated. And Councilmember Gim, thank you for speaking truth, that bringing forward real concerns about who is omitted from this legislation ought not be attacked by a council person as in support of criminal behavior. This is your bill, Councilmember Oh, as you've stated many times, please. It can be worded, it can be amended such that with this dialogue that has been called for by so many, I challenge the 21-year override of Pennsylvania statute around squatters' rights. We're talking about a 150-day emergency. 21 years is being overwritten in this policy. All that has happened today is that windows have been opened to show exactly how many situations can be erroneously passed through this bill. No one I've heard is offering testimony that this criminal behavior ought not be able to be rectified efficiently. Absolutely. Open. I ask that you open your heart and mind to holding the bill so that amendments can safeguard the well-beings of so many residents of Philadelphia that previous witnesses have testified for. Thank you.
Thank you for your testimony.
I appreciate that. I will have to make one point of correction. We are talking about civil procedures. We're talking about criminal procedures. There are civil and criminal procedures. There are legitimate tenants. There are tenants. There are adverse possessors that have legal rights under the state law. Those are all things that we're talking about. What I will clarify is that when we talk about, or I talk about, crossing over into defending or helping by limiting the discussion or the bill in an effort to protect low-income people into creating a process that is so obstructionist and so difficult for the lawful homeowner who has all the evidence against someone who occupies a building without any evidence, without paying rent, with doing damage to a building, with having broken into the building. That is not, at this point in time, talking about protecting low-income people. Now, that's a legitimate discussion that we can have. The issue that I have to correct is that if you want to win an argument, you can just change what the person is saying. I've at no time made any accusations, and to say that I'm making accusations is incorrect. I certainly appreciate your testimony. I am open to any intelligent offer of an amendment to solve this solution. I will say this, however, that up till today, and I've been in office for 6 years, and over the past couple decades, no one has offered a bill or an amendment. No one. And as much as we're talking about the possibilities of being overly broad, which I do not see, I believe that the homeowners, the ones who came and testified today, do need the protection of the police and the courts. One, I cannot control. The police work for the mayor. Whatever they decide to do, beyond my control, other than bring it up here. But the civil bill is a bill I offer, and I think it is way too late that it is being offered. And so if anyone has a amendment to offer, please provide it. But just delaying this process and talking about discussing and all that, it has been decades in the making from what I hear from one, at least a decade from what I understand, and I don't even have experience in this area. But I have dealt with the Lees, the McGees, and so many other people that have spent over 16 or 14 months in this process. So a bill, in my opinion, is being offered. It can be amended, but I don't want to delay it for the fact that someone doesn't have an idea what to do. If they had an idea, they could present it today, but they don't, because they never thought about it. I want it dealt with today, and we can amend it later. Thank you so much.
To respond, if I may?
Yes.
The proposal was for a dialogue to transpire.
That's somebody else's proposal. That's not my proposal.
Excuse me.
So you're not incorrect. Let me say there's two matters here today, a resolution for discussion, that is Councilman Tomberger's resolution. I offered a bill, which is very specific, which will be voted on, and some people requested it be held or vote no, or, I requested be voted yes. But there are kind of simultaneously two things going on today, so I apologize. It may be confusing. We have a hearing on kind of like what are the different points of discussion, and we have a bill. Two things.
The intelligence I have to offer on the matter is the expedited voting on this bill reflects a pattern of government in this entire country, reminiscent of September 11th. The Patriot Act needed to be instated tomorrow or today about it, and it has set this country off on a skid path of eroded civil rights. And so the intelligence I offer is share a breath. Thank you.
Thank you, thank you. Thank you all for your testimony today and your patience and for hanging out here until 1:15 to testify. So thank you very much. Thank you. I'd like to call the next panel, which is Della Haskell, Phil Lord, Tyrone Smith. Is Rita Baluta here? How about, is Della Haskell here too, or she's not here? Is there anyone else who wants to testify on this bill? Okay. Anyone else? Okay. Anyone else? Not yet. Not yet. I'll call you because we want to finish this panel. Is Ms. Chikamba here? Right back there. Okay, great. So I think we have Phil Lord, Tyrone Smith, and Rita Waluta.
Yes.
Why don't we start with Tyrone Smith?
Thank you. Hello, everyone. Thank you for allowing me to speak. My name is Tyrone Smith. I'm the chairman, founder, and CEO of the Laura C. Milner Foundation out of New York. I have a property here on the northeast side, or I think you guys call it Parkwood. I took it over from my grandmother that has dementia, and she was, wasn't in a good state of mind, so I'm helping her. And but the thing is, she actually didn't go through anything like this. My great aunt, Alice Johnson, she had a beautiful home around, I think it was 23 East Mount Pleasant and Germantown Avenue. So, as I think David, one of the council members said, we were talking about bad neighborhoods, but this was actually a good neighborhood, and it was the worst way. Some people befriended my great aunt. My great aunt has no children. I've been fighting for her since I was a little kid, so we've always been close. And my family is not really close together. They don't believe in taking care of their elders and stuff like that. So I'm the one. It always falls to me. I found people living in my great aunt's home. She had Alzheimer's. I tried to talk to my aunt. She would not let me in. Oh, actually, she would not let me get her out of that home. She was abused by these people. She was scared. She was physically and mentally abused. I've called the police. I'm an ex-police officer. And so I did everything I thought that I could do under the rights of the law, so I wouldn't put myself, because I'm furious. She's telling me that she's being abused, and she befriended, actually these people was watching her. She goes to the store a lot. They befriended her. Let me carry your groceries in the house. This is how, from what I can give. Once in, it was a done deal. They basically moved in, forced their way in, had fake documents printed up that saying that they was her caretakers. I've been through all of that. The police wouldn't let me get these people's ID. I was upset. I got it anyway. And they said, you can't do that. I said, I need to know who these people are. So the worst thing happened. She lost her home. She's living around the corner in a nursing home. Matter of fact, I was at the, you guys had a festival in Chestnut Hill some time ago. And I went to visit her because it's in the same neighborhood almost. And I looked at her, and nobody fought for her but me. Nobody, the city couldn't help her, the police couldn't help her. And what really hurts me is she lost her home. She doesn't know. She has Alzheimer's. She doesn't remember. I'm the one that's remembering everything. I'm the one that remember what she went through. I'm the one that's remember she was abused. She remembers nothing of nothing. Close to her, getting her out of the house, since she wouldn't leave the house because she was afraid to. I think you guys have a PCA or something like that, where you guys come out and I tell them to please take my grandmother into the, okay. Well, prior to that, neighbors called me, told me that it was a lady and a gentleman, they were cleaning out her house. They took all her expensive furniture, and she had nice stuff. This lady worked hard. She worked hard. Her husband is a retired vet. He passed away. She worked in the garment district for years. She's worked from nothing with a 5th grade education. She used to pick cotton down in the South when she was a little girl. She got tired of it, left, and moved to Philadelphia, and this is where she, she's 91 today. And, I try not to get too emotional up here, but I just don't understand, like, where is the love of a senior citizen to help in this time of need? We help our children. If you do anything wrong to a kid, you're done. And I understand that, but like, where is the help? Like when somebody's up in age and they're not thinking clearly. And then I point out to the police officer, I was like, she's saying she's being abused. The police officer took her down to the side, and the police officer asked her, are you being abused? She says everything that they're doing. They did not do anything. And I want to talk to the supervisor. The supervisor didn't want to talk to me. I was so upset. And come on, I've been a police officer in 2 great states, Oklahoma and South Florida. And, I believe in justice. I'm the campaign advisor for Beth Grossman. I believe in the law, and I believe in the will to help the people. I have a foundation that I created that does just that, and I just don't understand why my Aunt Alice has failed. She has to be not in her home, but in a nursing home, and she has no idea what happened. No idea. And there's nothing I could do. So basically, they stole everything out, cleaned it out. And then finally, when everything comes around and finally starts to move, her clothes is gone. We had to buy her new clothes. Everything is done. Everything is done. So I'm with Councilman Oh. I didn't know anything about it, but his social media is kicking pretty good. And then Beth told me about it, Grossman. And so I was like, I have to say something. I was born and raised here. I am a New Yorker now, but I'm still in Philly because I take care of my grandmother. And then another thing, real quick, what happens if I take my grandmother on a vacation to New York? She always wanted to go there, and I'd say I'm going to take her. What if I spend a week there? People know that area of Parkwood is a small area. They know that she lives alone. What if they break into her home, do the same thing, change the locks on the doors, then I come back? So it makes no sense. This is a common sense thing. It's a common sense thing. My grandmother bought this house cash money. And now, because I took her away on a vacation, I come back and I got to fight to get her back in her home. That's a what if. So I really, hope you guys can come together. I have respect for everyone up there, and especially David O, because he's right. He's addressing something, and this happened to Aunt Alice maybe 2-3 years ago. And I came from New York. I stopped everything. I was so upset. I couldn't even drive. I had my aunt drive me down here, and I could not do nothing. I went back to New York with these people in her home abusing her. And it was nothing. Nobody could do, not even the law. But let me go out here and a senior citizen in the street, and I'll slap a person or push them. I'm going to jail. But this lady's telling you she's been violated. They put their hands on me. It just happened not too long ago. Please help me. And they just look. And you know what I told them? I said, listen, I've been in law enforcement a long time. But I said, I'll tell you this. If this was your great aunt, it'll be different. And they just looked at me. And one of the officers nodded. I said, you guys, it's a brick wall here. Thank you.
Thank you for your testimony. But the district attorney's office and police department are still here. If you want to speak to them about this issue, maybe they can give you some help here now. I don't know if it's too late.
Well, her home is already gone, and she's living in a nursing home.
I know, but that doesn't make that right that she lost her home. That's terrible.
Yeah, they even took the clothes off her back, because once you guys got there to do the job for, the family's asking to get this lady out, for her protection. Well, okay, she's at a nursing home now, so they just.
Are these people still in her home?
No. I've skipped that big thing. They sold the home illegally to someone else, got the cash money, okay? The guy come back, and this guy was a legitimate guy. I don't know his name, but when he found out what was going on, then finally the wheels started turning. But they took the money, and they cleaned out her house. They took her clothes. She had nice clothes, mink coats. She saved every penny she had. She had no kids. She saved a lot of money. And so that's the outcome. She's in a nursing home now. And, even if she refused to let me take her out of that home, But I think law enforcement should have did something to stop, they're abusing her. They're physically and mentally abusing her, and nobody did nothing. They had these fake papers drawn up, and I do believe what Councilman Jim was talking about. Police officers are very professional, but it's like some things, like, you know, some things where there's a lot more paperwork, and like, they really don't understand. They do have a lot on their plate, but I do believe that they are the ones that could have stopped my grandmother from being abused, my great aunt, Alice Johnson, from being abused, because what if they went too far? She wouldn't have been 91 today, it would have been on a news clip, and who would have cared but me? And I got a couple other great cousins that kind of care when they want to, you know. So that's what I'm saying.
On behalf of the city, we're sorry that happened. That's horrible. And I don't know if we can do anything, but there are people from law enforcement in the back that maybe there's some sort of adjudication that can occur, but I would suggest you at least talk to them. It's not just...
The only thing I remember I did reports with the Philadelphia Police Department, and I've called on these people several times to get them out. They was not scared, and they look like they've done this before. And that's the only thing. There's probably some reports lingering. I don't know how to get to them. I guess by using my grandmother's address, the 23 East Mount Pleasant Avenue, maybe it'll show something that I was there and I was complaining, but, you know. So the only thing I was forced to do was to go to, I think you guys call it again, PCA or whoever, the seniors, they handle seniors, and to get her at least out of there. Listen, if they're gonna take the house, if it's all gonna go, I just want her safety. And so that's what I was thinking, because I was making so many phone calls, you would not believe, you know. So that's why she's in a nursing home now. At least she's safe, but I wouldn't want this to happen to anybody.
It's terrible.
It's a common sense, it seems like it's a common sense thing. And I know, I mean, come on, and I know police have enough dealing with laws on this and that, but you know what, we can't ignore this, you know, and, you know, like I said, people's lives are at stake, people's lives, because it could go either way, you know. Thank God that I'm a level-headed, try my best, you know, and ex-law enforcement, so I was really upset, but I really believed in the law to save my grandmother. But I do thank you guys for the PCA. They did a great job on getting her out of the house. My great aunt, to get her out of the house and to at least where she was safe and she would stop being harmed, you know.
All right, thank you for your testimony.
Thank you.
Ms. Waluda.
Hi. Good afternoon. Thank you for allowing me to speak. I am presently going through the situation with squatters. It has been 3 years. 3 years ago, I was getting my house renovated to move in with my mother, who was diagnosed with dementia. My father had passed away. I hadn't been there for maybe 10 days around the holidays. The work had stopped. The only thing left to be done on the house was to put pipes in. We were changing from copper to PVC. There was a tentative agreement of sale for $199,000. I lost that. When I went to the house to check on it, there was black material covering all the windows. They had the windows open with black material. I called the police. There was a woman in her 40s and a young kid, maybe in his 20s. She said, when the police came, she said she had a lease. I never got to see it. It was a crumpled piece of paper from what I could see. The police said they couldn't do anything. I said, well, I can get the deed to my house, and it was so obvious that they didn't belong there. The back door was kicked in, the other locks were changed, there were air mattresses in the house, there was no water, they had gallons of water, and that's it, in the refrigerator. The house smelled like a urinal, and there was used condoms all throughout the house and outside on the property. Now, this has been going on. I tried to get them out myself. A couple times I went, like with my family, and the police came and said I had to leave. The people laughed me off, and they've been there. I hired an attorney on March 15th of 2015, and since then we have been trying to get them out. They have stolen my identity, utilities. I have a tentative sale of agreement, and I'm trying to have, because the house is up for sheriff sale, because I did not pay the taxes, which I am intending to pay, but it was pending the removal of the squatters. I just got a call again last week that They try to transfer funds onto a credit card of mine. They've compromised my bank accounts. I've went to the postmaster with proof that mail had been going there, and they had taken it. Basically, they said, you know, whoever is in the house has a right to take the mail. There's just story after story. The Sheriff's Department, I believe, did come out, and I was not notified. My attorney said he got it after the fact, the notification. So they got an emergency stay, which is where we're at now. My lawyer filed, I mean, this has been thousands and thousands of dollars. My lawyer filed a writ for possession to get it back to stop this emergency stay, so I'm waiting to hear what happens next. I don't know where else to go. I've made endless calls all over the city, L&I. There's liens from the water department, the PGW. I never even knew about them because they were able to change everything out of my name. I don't know how. I even went, we were trying to find out what was owed so the tentative buyer would know what to expect. I wasn't able to get any information. They said it's HIPAA. Now, I'm a pediatric nurse, I understand HIPAA, but everything was changed without my permission or authorization. I don't know, it's 3 years, I'm almost giving up, you know, but I'm gonna lose everything over this. And I'm trying to stop the sheriff's sale, and my attorney sent the sale of agreement to, I believe, Mr. Zwola, the city attorney, and we're waiting to hear back. He said the city is not obligated to stop the sheriff's sale, but I'm trying to stop foreclosure or sheriff's sale, pay the taxes, and get rid of the squatters, and I am at a standstill, and I don't know what else to do.
Let me just clarify something. I want to make
Yes.
sure I understand. Are you saying that someone's been squatting in your home for 3 years?
3 years. They've been there 3 years.
Have you talked to any of our people in the back there
No,
about
I
this?
have not.
I think you should talk to them about this. I'd like you all to try to address this issue.
Okay.
Unacceptable.
Unacceptable is correct. My neighbors are so furious.
It's unacceptable.
It is unacceptable. I'm afraid they only live, I mean, we live a few blocks away. They know where I live. They are not afraid. Also, detectives notified me, I got this about a year ago, saying there was a person of interest living in the house using my address. There's like 15 different people using my address. They came, they showed me pictures, and they said it's a group of transgenders, which that doesn't make a difference. They're squatters, so I don't care what they are. They said I should not go over to the house at all. They fear for my safety, like, do not have any contact with them. So I have not been there. I just heard all the screen doors, the new screen doors. The house was completely renovated, ready to be sold. The screen doors are off. The door was kicked in. The neighbors are afraid. The property is all overgrown. I don't know what else to do.
So what I'd like you to do now is, I think we have here today Mr. Barry and Mr. White in the back. Maybe you could step outside and meet with them and see if we can get this resolved.
Okay.
Because for you, what you want to do is resolve this issue right now.
Yes, yes.
So let's see if we can get you that resolution.
Okay.
Thank you
All right.
very much for
Thank you so
coming in.
much for
Thank
listening
you.
to me. I appreciate it.
And Phil Lord,
Yes.
thank you for your patience.
Thank you for giving me the chance to do this. I know it's been a long day. My name is Phil Lord. I'm the Executive Director of the Tenant Union Representative Network. We assist thousands of tenants each year. We see them in our classes and our one-on-one counseling. And we see this problem from a different viewpoint, as you can imagine. First of all, I want to set a context, and I'll try to be brief. Philadelphia is on its way to being the eviction capital of the country. It has the highest eviction rate except for Miami. And that means that we put more people out than any other major city around except Miami. And with this law, I'm convinced we'll be way ahead of everybody else. Let me tell you why. According to Matthew Desmond, who was a scholar on evictions and wrote the book on it literally, 2/3 of the evictions that take place, forced evictions in the city, his city that he was talking about, Milwaukee, but he says this is true of the country generally, are not going to court. Right now, 24,000 cases are in court. That means 48,000 evictions are taking place in Philadelphia, if it's typical, without court process. This bill will make evictions without court process very easy to do. There are no safeguards for tenants in this bill. If a landlord lies, there is no penalty. This is outrageous. This is going to hurt a lot of people. They're going to go down to the landlord's going to go down to the police station, say, I didn't put this person in. They could have given the person permission to go in the property yesterday and go the next day down to the police station and say, I didn't do it, and the person's on the street. And And you may think that's far-fetched, but we see people, for example, young women who are moved into properties, and because they won't provide sexual favors, the landlord says, get out. Okay, get out now. The people that were referred to earlier, who were, and I think they were the people referred to earlier, came to our office long after we were in trouble. They were tenants. They came, they paid $4,200 to somebody, Craigslist person, gave them money, moved in, had 2 little kids, thought that was their home. When you give $4,000 to somebody, you have no money to move anywhere else. They found the name on Craigslist. They found out later on, according to people, that in fact they shouldn't be there. We told them, you're in trouble. You're going to get arrested. There is no one saying here today that the police can't arrest all the sad stories we've heard. The police can go even after the court case has gone through common pleas and everything else. They can still arrest those people and lock them up. We're not saying you shouldn't do that. We think you should. Anyone who's stealing property or abusing elders or taking advantage of women and doing sexual violence, they should be arrested. No two ways about it. But you can't do this thing, which looks like it's going to close a door and open up a huge door. It's going to say people can just go down and file an affidavit and evict their tenants. Who's going to go to court? Why am I going to go to court? Court costs money. I can go down to the police station. And let me say this. This bill seems to be premised on the notion that people don't know whether squatters are tenants or tenants are squatters, and they say the police don't know what to do. This is based on an assumption that the police don't know what they're doing. I don't believe that. But that's the rationale for this bill. And then it goes on to say that there's going to be a rebuttable presumption. How in the world can police who are having trouble figuring out what to do in enforcing a criminal statute, a third-degree misdemeanor, which is called trespass, which is clear as day. If you break into a property, you go to jail for up to a year. It's that simple, okay? It's not complicated, okay? How can police who you're saying have trouble do that resolve property issues, title issues, issues around lease fraud, and on a street curb corner, okay, and resolve that fairly and equitably? These things are in court because they're complicated, that's why. And if their lawyers don't know how to get injunctions, get people out right away, that's their lawyer's problem. They really are ways to deal with this problem. Police can go in there and arrest people, and they should be able to do that, and we think we support that. But this law doesn't add a thing to that power and creates a lot of confusion around what's civil and what's criminal. This law provides 90 days in jail. If you don't think that's criminal, then you got a different concept of criminal than I have. 90 days in jail. If that police officer says get out in 48 hours and you don't, you're in jail. What's not criminal about that? How in the world are we talking about not criminal? So let me say this. You may disagree with me. And like I said, I've seen the other side. I've seen like a young couple, in their early 20s, had 2 twins, beautiful young couple. They gave all their money to someone to rent a property, and then they found out the person didn't own the property, and now they had to leave right away or else get arrested. There is nothing in this city that enables a person who's being tricked on Craigslist to find out who is the right agent for the property. There's no way to find out if this person talking to you is really a relationship with the owner. And so you are vulnerable because there's no system to being tricked and scammed that way, and that's what's happening a lot, okay? But let me say this, bottom line is, this is a complex problem. The resolution about this conversation says that. If you rush this thing through, you're gonna be making a big mistake because, believe me, this is complicated and has backlash that we can't even understand right now.
All right, thank you very much for your testimony, thank you. We have, I think, a few more people, Ms. Shikomba, and there was someone else, I think, who wanted to testify. 2 more people, come on up. 3 more. We'd like to keep this to 2 minutes, please. Before we get started, is there anyone else who would like to testify today? Anyone else? So these are the last 4 people. Okay. Ms. Shikomba, why don't you go first?
My name is Madeline Shikomba. I represent the North of Washington Avenue Coalition. It's a community organization. I'm here today to speak on behalf of the squatters. I doubt there's a squatter in this audience. They too probably have their sad stories too. But you're not hearing them because they're not here. I'm starting out with a cartoon I saw in Mother Jones' magazine. It was a robot. The robot was standing up, he bent over, he had some money in his hand, and he was handing it to a homeless person sitting on the street. The homeless person was dressed in a business suit. Said a lot, a whole lot. Because you're assuming that all these squatters are people unemployed, miscreants, don't have no job, not even looking for a job. A lot of these homeless people, I'll have you to know, have degrees, lost their job because of downsizing, lost their home because of foreclosure, and now you're treating them like they dirt. Because you hear homeowners complaining. Philadelphia got the highest rate in terms of poverty, the highest. And we're not even addressing that problem, giving very little attention to it. So what are these people supposed to do? You don't have enough housing. You don't have enough places for them to go to stay. So they're on the street. So they find a place they can stay. Not to say it's legal or anything like that, because I'm a homeowner, so I understand that perfectly clear. But you got to find a problem, and kicking them out is not solving the problem. You're just pushing it aside somewhere else. Okay? We have unemployment, millions. Yesterday I had a job report. Oh, we're going to create 200,000 jobs. What is 200,000 jobs when you got 5 million people unemployed? That's a drop in the bucket. And it's going to increase. Why? Because they're going to replace us with robots. And then where are these people going to find a job? The homeless situation is not going to go down with this law. It's going to get bigger and bigger and bigger until we come up with something that's more suitable than what you have come up with. Okay? You're creating, to me, a debtor's prison. Here you want them to pay a fine or go to jail. They ain't got no money to pay a fine, so what you going to do, keep them in jail until they find a fine? Is that what you plan on doing? That's what it sounds like. If you ain't got no money, and you're assuming these squatters can afford to pay you $300-something, that's kind of stupid to me. I would be a squatter if I had $300-something. Yes, there is a criminal element. I'm not denying that. But that's a small element. Wherever you got people having problems, you're going to find crime, and you're going to find somebody who's going to exploit it. But don't blame the masses for that exploitation. It's like people on welfare. 1 or 2 people sit up there and they run away with the welfare system, and then you're going to blame the millions who are honest, living people for the responsibility of a few crooked folks. Okay? So this bill has to have some safeguards. They don't have any safeguards for the legitimate people who are squatting. Okay? You give them people 48 hours. You don't even give them 2 business days. At least if they had 2 business days, they can contact a lawyer or something. Like the lady said, coming in on Friday and you out on Sunday. That ain't even in there. Okay? So, like I said, this is a rush to judgment. I think the bill needs to be more thought out, and that's why I support the resolution. You need to have more thought on this. You know, right now, you're looking at expensive for the homeowners. Okay? Most of these people have homeowners, they can't afford the expense. I understand that. Nobody can. I'm really with them on it. But they're out of the home. For the other person, expensive for the squatter, it's incarceration or pay a bill that you don't have the money for and still you're incarcerated. Okay? You have to think this out. And a rush to judgment to satisfy all these homeowners is not going to be the answer. You're creating a much bigger problem. So I suggest that you hold back, step back a few steps, take your time, and they already got their problem. They're going to be solved right now. Okay? So, I see no rush.
Their problem hasn't been solved
But I'm
3
saying to
years,
you, I know
2
the
years.
problem has not been solved and stuff like that, but their problem has been ongoing for a while. Okay? And you rushing to pass this is not going to create any solving for the problem of this man who had it for a year with his mom or somebody else for 3 years. They ain't going to solve it either while you rushing this bill through. Okay, so don't act like that's going to be a panacea, because it's not. So like you rush something in, You know, you got to back it up, and then you say, oh, yeah, we didn't think about that. Okay, like you said, nothing been done in years, so what's the rush now? You might as well sit back and try to get some dialogue going so we can come up with some kind of proper solution, because rushing it through ain't going to add no more but another bigger problem.
All right, thank you very much. Thank you for your testimony. Next, we have, well, you have to announce your names. We don't have your names.
Yes, good afternoon, council. Thank you for the opportunity.
Please announce your name and...
My name is Barry Thompson. I'm Vice President of the Philadelphia Tenants Union. I'm very sympathetic to the homeowners and their situation, but there is an eviction crisis in the city of Philadelphia. And at the end of the day, I think, me too, think we should step back and take a moment and look over this bill, because at the end of the day, even there is criminal charges, and even after the day, even after being put in jail, the eviction crisis is still there because the criminal, whoever, is still coming home being displaced. I felt a little uncomfortable with being as a squatter, because I once was a squatter, and being considered as a criminal was very unjust for me. My thing is, like the councilman, Talkenberger, is to come up with a solution, because squatters been in effect in the city of Philadelphia for years. It just didn't happen when you came in office, you know, because when I was renting from a squatter, a landlord who was squatting the house, but the city continued to give him license to continue to rent property out in the city of Philadelphia, even after knowing that he was doing things illegally. That's when the crisis came about. So me too, thinking that this bill should be stepped back and take a moment, and let's come up with a resolution. And for me, I think good cause is the only solution to this problem.
Thank you. Thank you for your testimony. Is there anyone else who'd like to testify? Yes.
Okay. So, hi, my name's Stephanie Altamari. I'm here with the Philadelphia Tenants Union. So I'm going to keep it brief. First of all, I'd like to state that I'm morally offended by the language being used today, referring to homeless people as criminals and people that own properties that they don't even live in as victims, when the balance of power is so obviously skewed in a homeowner's favor. Also, I find the timing of this bill, as another freezing Philadelphia winter approaches and as Philly makes a bid for Amazon's headquarters, both reprehensible and politically convenient. You're condemning your most vulnerable citizens to death or jail for the sake of profit. This bill does nothing but criminalize homelessness. You seek to arrest those who are merely trying to stay alive, literally. It does nothing to attack the root of the problem, which is a lack of affordable housing in the city of Philadelphia. This bill will only place tenants on verbal leases in a more precarious situation, as several other people have stated. This bill merely serves the interests of people to seek to further gentrify our city, which will do nothing except to swell the ranks of the homeless people on our streets, whom I'm sure you'll seek to hide out of sight in prisons and jail. As of 2015, there are about 25,000 abandoned properties in Philadelphia, and probably an equal amount of homeless people. They all seek shelter, and they all deserve shelter. It's often conveniently forgotten that homeless people are citizens too. There's no reason those properties cannot be turned into designated affordable housing rather than a profit mill for developers. The only way to solve the squatter crisis is to provide free or affordable housing for all. Thank you.
Thank you for your testimony.
Hi, Council. My name's Rue Landau. I'm the Executive Director of the Fair Housing Commission. I wasn't originally planning to testify today, but after hearing so many compelling people speak, I wanted to make sure to lend our voice as well. So the Fair Housing Commission was established to enforce Chapter 9-800 of the Philadelphia Code. We deal with unfair rental practices in rental housing, and tenants file complaints with our office. We often see the cases that don't go to municipal court and don't go to the Court of Common Pleas. We see landlords, we see about 350 cases a year. We see landlords without licenses, without certificates of rental suitability, and oftentimes we will also see people who are posing as landlords who do not in fact own the property, but have been receiving rent from tenants for years and years. We see many oral leases, We see many cash payments and no receipts. We see very complicated cases. And even though those cases are complicated and it is hard to establish a landlord-tenant relationship of sort, our commission listens, provides a forum in order to have some due process, to hear from both sides, and to see whether or not a relationship exists. But as the folks who were just on my panel said, this is not a fast process. This is a slow process in which we have to listen and do our best to see if we can find evidence to see which way the cases go. Just last week, in the past couple of weeks, we saw a case, in fact, that the owner of the property was calling a tenant a squatter, doing something odd and going, I believe because he didn't have a license, going to the Court of Common Pleas, getting the tenant out as a squatter, when in fact we were holding a copy of her lease from 1992 and a stack of correspondence between the landlord and tenant over the years about repairs and other issues. But instead, he chose to call her a squatter to try to say that she had no rights to be in a property and move on. These are very, very complicated issues. Each case is individual and specific on its own and needs the time for all of us to come together, to come up with some answers and some solutions to the problem, but absolutely without a rush to judgment. The mayor, along with initiatives sparked by Councilwoman Gim, has created an eviction task force, of which I am a part. That's a great place for us to start looking at some of these issues as well. These are serious issues, there is no doubt. There are some people who are getting harmed and some people who are getting scammed in the city of Philadelphia. But I would really urge you to vote to hold Bill 170827 so that we can have a thorough review and much more conversation and dialogue about this. I can't thank council enough for taking these issues up now. It's been a long time. I spent 10 years at Community Legal Services before my 9 years now at the Fair Housing Commission. The issues that have been persistent throughout the city are finally getting the focus that they deserve, and it includes us collectively trying to deal with the problem of our poverty, for low-income tenants, for a lack of affordability and a lack of high-quality housing in our city. And I think now is the moment that we can find the solutions to the problems.
Thank you for coming. Thank you for your testimony today. Councilwoman?
No, I just wanted to say thank you again, Ms. Landau, for the work that you're doing at the Fair Housing Commission, and just clarifying again that it looks like the law department, I know it's been said before that the police are the determiners around this, but it looks like the amendment put forward by the law department would like to see the Fair Housing Commission also be a significant determiner around whether properties are appropriately being handled.
And we appreciate
that. And that's
that.
your work.
Yeah, absolutely, and want to help in any way. I mean, I think the law department has done an excellent analysis of the bill in the time that they had. The Fair Housing Commission, we've got 5 commissioners who preside over hearings, and multiple commissioners who are lawyers. They take their time. We always have a court reporter at our hearings. We are established in a way for many trials and can handle these cases.
Thank you. Does anyone else wish to testify on this bill? Last call. Okay. Councilman Oh?
Thank you very much. I do have an amendment to the bill that had been previously discussed, that is to exclude gardens from the definition of the property. I will say that the wonderful thing about democracy is that we have to vote. And we do that publicly. Here, everything is transcribed and it is being broadcast. And there have been statements made on behalf of various people. The issues of poverty, poor education, those are issues we deal with, and we address them. Evictions are certainly a sign of problems that exist. However, solving them by allowing people to live in somebody else's house to break in with impunity is not a very good solution. This issue has been unaddressed, not addressed. And a lot of the sympathetic people who I respect and I appreciate your work are certainly not the people who have had their homes broken into or their family members abused. They are champions of letting people live in a house, whether it's somebody else's house or not. This process is long overdue, and the issue is I put forward a solution. I don't know what discussion needs to take place over a very simple issue. Breaking into a home, claiming to be a tenant without any evidence of it, when the homeowner has the witnesses, the evidence, and the documentation that this home is not rented or leased. The police don't act, and I wish, as Phil Lord said, they would arrest where arrest is needed, but then somebody will oppose that as well. If the police, who are here, will start arresting people when they need to be arrested, that'd be a great solution. When they don't, there's a process to have an expedited hearing, due process under the court, so we can resolve this. We will publicly vote on that, and at the end of the day, that is democracy in action. Thank you.
Thank you, Councilman. This concludes the public hearing on Bill number 170827. We will go into a public meeting shortly to consider the action to be taken on Bill number 170827. Thank you, everyone.
Okay, I will have an amendment to introduce. All right, this time I would move that an amendment to Bill number 170827 be adopted by this committee. A copy of the amendment, which, as described, excludes gardens from the definition of bill of property as defined in 170827, be adopted.
It's been moved.
Question?
Okay.
A question for this. Am I allowed to ask a question?
Yeah, sure, go ahead.
Okay. So one of my questions is that we have just recently received, I know the councilman is proposing an amendment to his amendment for the bill, but my question, I guess, is on the validity of the amendment overall, given the fact that, that the law department has just handed us an 8-page memo with 5 pages of amendments to the law itself. I mean, clearly the 8-page memo from the law department says that the ordinance is likely to be in violation of Pennsylvania state law, that it does not provide adequate due process protections, and it subjects the city to substantial financial liability. In addition, none of the amendment has been discussed with the administration or the city departments and commissions that have responsibility under the bill as revised to determine if the provisions of any amendment are practical or advisable, nor have the policy matters addressed in the amendment been discussed with the relevant city departments and offices. While I don't disagree the fact that I think that anything should eliminate or exclude gardens, I am not clear about why we would move forward on an amendment that is on its face already problematic according to law.
It's a procedural issue, so we can vote on the amendment that is amending the bill to exclude from the definition of the property gardens, and then I can address your question.
It's been moved and properly seconded that the amendment to Bill number 170827 be approved. All those in favor of the motion will signify by saying aye. Those opposed will be nay.
Aye.
Is it unanimous?
Yes.
Okay, it's
Gardens,
unanimous for
yes.
gardens, okay. The ayes have it, and the motion carries. The amendment to Bill number 170827 has been approved.
At this time, Chairman, may I answer the councilwoman?
Sure.
Yes. So I did read the City Law Department's memo. I don't find credibility in it at all. Very similarly, I would say that in the history of our city, for example, the Law Department seems it's okay for the police to enforce L&I rules that don't even have regulations that have targeted the closing of Chinese takeout restaurants 96%. I think that's illegal and unconstitutional, but the law department doesn't have much to say about that. Stop and frisk is unconstitutional and illegal. The law department did not have much to say about that either. I think that is a problem. And when it comes to the core fundamental thing that the police do, enforce the criminal laws of which they're trained to do, the law department says the police are not equipped or capable of doing that. I would have to reject that. Thank you.
Thank you, Councilman. Councilwoman Grimm?
I'd just like to point out the law department has weighed in on different aspects of stop and frisk and other types of, including the current bill that you referred to and regarding to the unconstitutional enforcement around the takeouts. They are also very clear that in this particular memo that they were not consulted ahead of time. I think it's important that any time any bill gets substantially rewritten, that there is some consultation with the law department, and that they are very clear that the ordinance could be in violation of the Pennsylvania Landlord-Tenant Act, which has been in place for over 70 years, I believe, and does not provide adequate due process protections, and again, subjects the city to financial liabilities. So they recommended they have an 8-page memo, 5 pages of amendments. It seems pretty clear that this is something that needs to be seriously reviewed and taken under consideration before moving forward.
I again respect your opinion, and you're free to do that. I choose not to. I am very comfortable with the law in this area. I will say that I do disagree with the law department at times, including the fact that they believe that the parking authority is properly taken over by the state. I have introduced bills to take it back. I believe it's unconstitutionally taken. I think the money is improperly used, and I've said so time and time again. But the law department disagrees with me on that. That doesn't stop me from introducing bills. However, my bills haven't moved forward. And so we shall see. But this body will make a determination. Sometimes we agree with the law department, sometimes we don't. And we'll have a vote, and it'll come to an end.
Thank you. I'd like to call a recess for a moment. I want to have a little discussion among my colleagues, and we'll come right back to you. Thank you. Okay. Chair recognizes Councilmember O for a motion on Bill number 170827.
Thank you very much, Chairman. I move that Bill 170827 be reported out of this committee with a favorable recommendation. Further, that the rules of council be suspended so as to have a first reading on the first session of council after this bill.
It's been moved. Do we have a second to the bill? Is there a second to the bill? I'll second it just to keep it going, but fine. It's been moved and properly seconded that the bill 170827 be reported from this committee with a favorable recommendation, and further moved that the rules of council be suspended to permit first reading of this bill at the next session of council. All those in favor of the motion will signify by saying
I ask for a
aye.
point of order, if I could
Sure.
have. A point of order is, I'm going to be very blunt and tell the folks that are here and anyone else that's listening. Look, I saw 2 break-ins myself, but I also listened to testimony today, and that was the reason for this and the reason we have testimony. I like to read things. I don't like to be like some people in Congress and say, well, read about it after we pass it. Well, I want to read about it before we pass it. So what the law department has written, I want to digest. So I will be voting no on this because I believe flawed legislation will do nothing to further the families that were here today. Thank you. Oh, well.
Chairman, I'd also like to make a statement. It is also my opinion that I will vote no on this bill moving forward as well. It's the Housing Committee's responsibility to ensure that any bill that moves forward is solid and has the committee's fullest confidence before anything moves forward. Representative Taylor is moving rapidly on a bill that gives us much-needed clarity and will be done by the end of the calendar year. I trust him to do this, and I do not believe that council needs to move ahead of state law that is already in motion. The testimony that came forward, particularly from our legal services communities and from others, raised substantial concerns and validate what our law department itself says, which is that the law is likely to be in violation of Pennsylvania state law, that it does not address appropriate due process considerations, and as such, it is wrong for us to move forward on anything, especially when the sponsor of the bill has not had an appropriate dialogue with the law department, has not sought their opinion on it, and is now asking the committee to take into consideration an 8-page memo with 5 pages of amendments that really could have and should have been worked out ahead of time. I look forward to supporting Councilman Taubenberger's hearings on this and continuing further dialogue and discussion. None of us on this committee support in any way criminal behavior, will not tolerate, and will defend all of our residents' rights to their due property, but we will not upend decades of important law on a rush judgment, and thus I will be voting no.
Thank you, Councilwoman. I'm going to give you my reason why I seconded the motion, though. I feel for the victims, but by the same token, I'll be very honest, I asked the Councilman Oh to give 30 days for discussion of this and include all the parties, but I want to set a deadline because I don't want to be revisiting this in May of next year and hear more about more people that have been broken into and squatters and so forth. So I'm in favor of moving it forward, but with a 30-day discussion. I don't want to be hearing about this in February or March. We need to act on this now. And I need a commitment from all the people in this audience that within 30 days, we're going to get this resolved with both councilmen. We're a team. I'd like to see us work with Councilman Taubenberger's resolution and Councilman Oh's bill together. We are here together to help everyone in the city. So, as my colleagues pointed out, that was my reason for seconding the motion. I'm not going to vote for it. But I want to tell you that this is important. I'm glad that Councilman Oh brought it forward. I'm glad that Councilman Taubenberger brought the resolution forward. It's important. You hear the victims. You heard what, 150 days. You heard somebody 3 years with someone in their home. Can you imagine your own home? You go home and someone's in your own home and you can't get back in for 3 years? Unacceptable. So I just wanted to put that on the record. Anyway, it's been moved and properly seconded. And that bill number 170827 be reported from this committee with a favorable recommendation. Further move that the rules of council be suspended to permit first reading of this bill at the next session of council. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed?
No.
No. I believe it's 4-1. The noes have it, and the motion will not carry, and the motion fails. But with the caveat, I just want to say as the chairman, I would like us to come back within 30 days, revisit the issue. All the groups that testify with issues, we get it, we hear it, but I want you to meet with both council people and get this resolved, and maybe jointly we can have something that solves the issue. Thank you, everyone, for your time today. Thank you very much. I'm going to call it quickly. 30 days. What's that?
Thanks, everybody.
I'll never get done.